Your Lordship permission to pray for an accommodation, my lord. I am coming from Calcutta, and you can visualize seeing me that I am sufficiently aged. This is the one urgency personal. Item number 51. Today is fixed for hearing. One is my personal reason, and another is Honorable Appellate Court has requested your Lordship to hear this matter as quickly as possible by this order dated 21/4/21. Request is made, my lord. Paragraph 5. Since it is an old matter, we request the learned single judge to recite the same as expeditiously as possible. And another urgency, my lord, my personal reason. I am sufficiently also, I can return to Calcutta tonight. If it is subject to your lordship convenience, if it can be upgraded, I can complete my argument because I shall be as brief as possible. I have prepared the written notes of argument that I will submit. I may not take more than half an hour or 30 minutes. Only I have to show some few points of law and some ruling of the Honorable High Courts and Supreme Court. That's all. And
First
only
item
one
of
point
hearing.
to be decided. Really
First item of hearing.
Ah.
Take it as first item of hearing.
hearing.
First
Grateful.
item of hearing.
Grateful, my
Please, Lordship, my lord, I beg to mention item number 38, my lord. They filed the counter, my lord. I want to file the reply, my lord. Let it come after vacation. Item 38.
Item 38.
The other side lawyer, I could not meet, my lord.
Mr. Arti Sharma, as senior counsel appearing for the additional submit that copy of the counter affidavit filed by the respondents has been received, and therefore he will be granted 3 weeks time to file rejoinder. They are allowed. Let this matter be listed again after the summary.
Oblige.
Well, I beg to mention one item, my lord. May I please that the item may come up next week, my lord, for admission, my lord. Urgency is there, 2020 matter, my lord.
2020 urgency.
My lord, because regulation of casual labor, my lord. That is the question, my lord. For admission, my lord.
You do it
because
after vacation.
My lord, he has not filed, they have not filed the counter affidavit, my lord. Until they come. On 2 occasions, they took time, my lord. Right? By the time I have not been listed, my lord. Next week, any day, my lord.
23rd June.
My
Lordship, I'm appearing for the respondent. Lordship, on stay vacating petition was there. Lordship, given 2 weeks time to the petitioner to file affidavit. Registry put it on 7, but as court was not on 7, so that matter was not listed. Can it be on Monday, Lordship?
May I please, Lordship? Lordship, I beg to mention item number 28 of today's daily list. Lordship, may it be listed after 2 weeks, and because we have to file additional documents in this matter.
You are appearing for whom?
For the petitioner, Yunanda.
Should we see you Nandan and counsel appearing for petitioner? Submit that some additional documents are required to be filed in this case on behalf of the petitioner, and therefore this matter be adjourned to be posted again after the vacation.
Okay, Lordship, any date may be given.
Where allowed that this matter be listed for motion immediately on reopening of the summer hearings.
Oblige.
May I please, your lordship? 2000. I beg to mention 2018, my lord, appointment related matter, my lord.
After vacation. After vacation.
My lord, after vacation, date. I'll put a date after vacation.
Yes, yes.
Oblige.
May please, your lordship. Lordship, I am to mention a new case, my lord, contempt case 339/2023, my lord. Last occasion, I have made an adjournment in this court, my lord, but matter didn't list yet, my lord. Your lordship was granted 1 week's time, my lord.
What is the matter? Contempt case.
Contempt case, my lord.
Contempt case will have after vacation. What is the advance?
My lord, on second, I have made a adjournment, my lord.
We'll delete the vacation and work during vacation. That is one option. Huh?
Lordship.
After 2 weeks, I'm not giving any fixed date. After 2 weeks.
Lordship.
Yes.
But this is my prayer, it may come up for admission in the second.
May please, your lordship. Lordship, in regard to item number 11 of today's list, lordship, can I pray for an adjournment in this case, lordship? Can it be taken up in the next week, lordship?
On the prayer of learned counsel for the petitioner, this matter gets passed over for a week.
Deeply honest.
May I please, your lordship, item number 37.
Your Lordship, due to some personal difficulties, my senior could not be present today. We have taken consent from the petitioner, counsel.
You are for whom?
I'm for the respondent too.
Learned counsel for the respondent number 26, adjournment of admission hearing of this case on the ground that the arguing counsel is unavailable. Since the prayer is made with the consent of the other side, same stands alone. Let this matter be listed for admission after the vacation, after the summer vacation.
May it please your Lordship, I beg to pay before listing this matter, Lordship.
What matter?
Lordship,
What matter?
for promotional matter, madam.
The listing for what?
Admission, Lordship.
After vacation. Yes, next matter.
For listing of an case, Lordship, hearing method,
After vacation.
27 July, Lordship.
From last appears for the petitioner when the matter is called up. The petitioner's counsel was absent even on the two consecutive occasions in the past. First of, even on the two consecutive past occasions when this matter was listed before this court. First of. Mr. S.S. Royal and Government Advocate Assam is present on behalf of the state. Having regard to the nature of issue involved in this writ petition and the relief sought by the petitioner, it appears that due to long lapse of time, the petitioner has lost interest to pursue the matter before this court. As such, this writ petition stands dismissed for non-prosecution.
Obliged. Lordship, may kindly pass over the matter for the time being.
Pass over, no, what is the matter?
It relates to promotion, Lordship, to the post of assistant engineer, Lordship.
Promotion.
Lordship,
What is the relief you want?
I want promotion, Lordship, when there arose vacancy in that post, Lordship. And my juniors were promoted prior to me, Lordship.
What is your client holding? Which post is he holding now?
Lordship, he was subsequently promoted to the post of assistant engineer. But then we want it from the date his juniors were promoted, or at least from the date when vacancy arose in that post.
On what ground? What is the ground for that prayer?
Lordship, 30% of the vacancies were to be filled up by promotion, and the respondents have not considered us against that 30% quota, Lordship.
30% quota meant for whom?
Lordship, brief and not.
I'm so sorry. Then we'll dismiss for non-prosecution. You file restoration.
No, Lordship.
No, this top of the list matters will not be adjourned. Sorry, can't help it. This has been already notified. Yes, you argue, will decide the case.
My lord, he came before this honorable court in the year 2012 with a grievance of 11 years back.
Not 2012, 2011.
Sorry, 2011, my lord, of a grievance of 11 years back, my lord.
So,
In fact, my lord,
petitioner-
he was promoted in the year 2002, my lord,
Promoted
And-
to what?
to the post of assistant engineer from the post of junior engineer. My lord, the rule says, my lord, authority cannot exceed 30%, not that 30% has to be filled up from amongst the junior engineers. Authority cannot go beyond 30%.
So he is still serving as assistant
My,
engineer.
that is not my knowledge, my lord, because it is a matter of 2012, sorry, 11. कोण आहे? कोण नाही? मी आहे बोलत. काय बोलत? This one. That one is again this one.
Nice.
Yes.
This would be-
Even the basic one, it's a number like that.
Yes, you're right. And 1700 is good.
Sort of like that. Right, you know, this is something.
Yeah, 58 years or something. Yeah, 58 years or something. Yeah.
Where is the, where is the rule? Is it a part of the record?
No, they have not.
Lordship, I'll provide it, Lordship.
No, I'm disposing of this matter right now. Whatever you have to do, you do now. No adjournment, no accommodation in top of the list matters. We are not sitting here for,
May I please?
yes, please.
In chief. 11 chief, right? In- 11-3, my lord.
Not to exceed 30%.
They were appointed in the year 2002. They came before this honorable court, alleging.
2011.
Yes, in the year 2011.
There are two petitioners.
Yes, my lordship.
They claim seniority over respondent number 6 to 13, who are direct
But they're right.
recruitment. And they were appointed earlier in March 2001. And the selection board
2002.
cleared 12 in December 2001, the selection.
Yes,
was held.
that is by APSC
4
2021.
posts were advertised, Lordship. Against those 4 posts, Lordship, 8 incumbents were promoted, Lordship, directly recruited, Lordship. And we had grievance against them, Lordship, and we had filed our representation at that point of time challenging those appointments, Lordship. And subsequently, Lordship, even appointments were made under regulation 3F of the APSC regulations, Lordship. They were regularized. Lordship.
Now, will you start arguing on establishment of the department from there? What is your case? What is
Lordship,
your case?
there were posts lying vacant against that 30% quota, Lordship, in 1999 and 2000 itself, Lordship.
So you should have come then. When did you not, why did you not come?
Lordship.
You are saying the vacancies arose in 98 and 2000.
But the gradation list that was published, wherein the incumbents which were directly recruited were given seniority over us, was published in the year 2010, Lordship, and we put to challenge that gradation list, Lordship, challenging their seniority over us.
Yes, they were appointed before you.
Lordship,
They
that-
came into the, they were born into the cadre before you. They will be senior.
Maybe Lordship, but we were required to be
All right,
considered
heard
at least
Mr. MP
for the.
Sharma, learned counsel appearing for the writ petitioners, also heard Mr. B. Goswami, learned additional AG Assam appearing for the Water Resources Department. You are there, Ms. P. Sharma, learned, Water Resources Department. That is the respond numbers. Lodge. Respond numbers 1, 2, 4 and 5. Full stop, Ms. P. Sharma. Learned counsel appears for respond number 3. Who is for 6 to 13? None has appeared for respond number 6 to 13. Full stop. The writ petitioners herein have approached this court by filing the instant writ petition, alleging that their cases for promotion to the post of assistant engineer bracket mechanical bracket close in the flood control department ought to have been considered against the vacancies arising in the year 1998, 2000 and 2001 respectively. However, on an erroneous construction of the provisions of Rule 11, Sub-Rule 3 of the Assam Engineering bracket Flood Control Department bracket close Service Rules, 1981 bracket of hereinafter referred to as Rules of 1981 bracket close. The respondents have delayed the promotion of the petitioner. First of thereafter, the private respondents who were direct recruitives were given seniority above the petitioners by ignoring the objection raised by them. First of this writ petition has therefore been filed with a prayer to inter alia set aside the notification dated 11/6/2002, by means of which the petitioners were promoted to the cadre of assistant engineer bracket mechanical bracket close with prospective effect, with a consequential relief of giving retrospective effect to their promotion with effect from the year 1998 and 2000/2001, full stop, semicolon, full stop now. To declare that the petitioners are senior to respond numbers 6 to 13 in the cadre of assistant engineer bracket mechanical bracket close, and also to quash the provisional gradation list dated 9/6/2011, wherein the private respondents have been shown to be senior to the writ petitioners. Full stop. Mr. Sharma has argued that the authorities ought to have reserved 30% of the posts in the cadre of assistant engineer bracket mechanical for being filled up by way of promotion. Full stop. Had this said provision been made, the petitioners would have got promoted prior to the appointment of the private respondents, in which event,
Rule 11. In Rule 11, it is provided, Lordship.
in which event they would not have lost out on their seniority. Full stop. Mr. Sharma has, however, admitted that by notification dated 11/6/2002, his clients have been promoted to the post of assistant engineer bracket mechanical. Full stop. Mr. Goswami, learned additional AG Assam, on the other hand, has argued that Rule 11 Sub-Rule 3 merely provides that the vacancies to be filled up by way of promotion of sub-engineers to the post of assistant engineer shall not exceed 30% of the total cadre strength. Full stop. There is no mandate under the rule which requires 30% of the post to be reserved for being filled up by way of promotional candidates, by way of promotion of departmental candidates. under the circumstances, submits Mr. Goswami, this writ petition is misconceived, full stop. The learned additional AG has further argued that the promotion given to the petitioners with prospective effect was dated 11/6/2002. Full stop. Notwithstanding the same, they had approached this court by filing a writ petition only in the year 2011. Full stop. Therefore, the writ petition is hit by the principles of delay and laches and is liable to be dismissed on such count alone. Full stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record. I find from the record that the private respondents were appointed as assistant engineers in the Department of Flood Control, bracket now renamed as Water Resources Department, bracket close, as direct recruits. In the month of March 2001, full stop, the writ petitioners who were serving as sub-engineers were promoted to the post of assistant engineer mechanical by notification dated 11/6/2002 on the basis of the recommendation made by the selection board in its meeting held on 29/12/2001. Full stop. It is therefore apparent that the private respondents were born in the cadre of assistant engineer prior to the date on which the petitioners were promoted. Full stop. It is not the case of the petitioners that the appointment of private respondents were divorced the rules.
Lordship, it's a case, Lordship, because
It is the case of the petitioners that the appointment of the private respondent will divorce the rules. However, from an examination of the where is a prayer to set aside their appointment? It is the case of the petitioners that the appointment of private respondents is divorce the rules. However, there is no prayer.
notification,
Huh?
one Lordship, 11/6/2002, Lordship.
Hmm. This is 11/6/2002 is promotion of your clients. However, there is no prayer in the writ petition to set aside their appointments. Therefore, the question of validity of the appointment of the private respondents number 6 to 13 need not detain this court. The fact of the matter is that the writ petitioners became assistant engineers subsequent to the date on which the private respondents were promoted, were appointed to the cadre of assistant engineer. Therefore, it cannot be said that the petitioners ought to have been assigned seniority above the private respondents in the provisional gradation list dated 9/6/2011. Full stop.
And they did not
Insofar
submit
as-
any, they did not submit any representation. My lord.
Lordship,
Moreover-
it's there at page 44. We had
No,
submitted.
in respect of my lord,
Moreover, as per rule 11(3) of the rules of
provisional gradation list or against the petition.
rules of 1981.
Issue.
As
Provisional
moreover, rule 11(3) of the rules of
9/6/2081.
1981 merely puts a ceiling of the total number of total percentage of posts, bracket 30%, bracket close, which can be earmarked for filling up. Total number of posts in the cadre of assistant engineer, bracket 30%, which can be earmarked for being filled up by promotion of sub-engineers. Therefore, the said rules does not say that 30% post must always be kept reserved for being filled up by promotion of departmental candidates. Therefore, the argument advanced by the petitioner's counsel that had 30% post been kept reserved for being filled up by way of promotion of departmental candidates, his clients would have got promotion at an earlier date. Full stop. What is also significant to note here in that
9/11.
although the
9/6
petitioners have claimed their right to be promoted in the year 1998, 2000 stroke 2001, yet they did not approach the court ventilating their demands in the matter at the relevant point of time. Full stop. Even subsequently, that is after the gradation list was published, the petitioners have waited for nearly 10 years before approaching this court. And the only explanation for such delay is that their representation was pending before the authorities. Full stop. Law is well settled that pendency of representation before the authorities is no ground to condone the delay. Full stop. Therefore, having regard to the facts and circumstances of the case and the prayer made in the writ petition, this court is of the opinion that there is no merit in the writ petition inasmuch as the relief sought by the petitioners is not maintainable in law as well as in the facts and circumstances of the case. This writ petition is therefore held to be devoid of any merit and the same is accordingly dismissed. Yes.
Lordship, as per rule 11, Lordship, the vacancies were to be assessed.
Walk down straight, take a right turn, there is a division bench.
Lordship.
Yes.
Please, your Lordship. Lordship, the matter pertains to interstate seniority in the cadre of Assistant Inspector in the Excise Department. If the Lordship will take up item number 3 first. 2013 matter, your Lordship.
Yes.
Your Lordship, there was an advertisement dated 7.
What is the case number in item 3?
5481 of 2013. Item number 3 and item number 4 is 8027 of 2018. 8027.
Yes. Yes, what is your case?
Yes, your Lordship, there was an advertisement in the year 1991 for the post of.
Just give me a minute.
Yes, yes.
And what is the second writ petition?
The second writ petition, your lordship, is a subsequent promotion of three juniors in the merit list who were promoted. But that was, the second writ petition was filed to assail their promotion. The issue is same, your lordship. The second writ petition is the fallout of the first writ petition. The fact of the matter is that the appointments were not carried out as per the merit list.
Promoted to which post?
Inspector, your lordship. In the excise department. Your
So
lordship,
you are aggrieved by the gradation list dated 5/8/2000.
5/8/2013 and the order, which is at page 40, your lordship. Will kindly see the order of respondent number 2.
Yes, page 40.
Yes.
Page 40 of which writ petition?
The first writ petition, your lordship. 5481, your lordship. This order was pursuant to the direction of this honorable court in WPC 5278 of 2012, where representation of the petitioner was sought to be considered. The excise department, your lordship, respondent number 2 stated, if I may be permitted to read.
So where is the order of the High Court by means of which you were appointed?
Yes, the lordship will kindly come to page 20, your lordship. Page 20. Page 20 is the first writ petition preferred by petition number 1, your lordship. The lordship can come to page 22 for a moment, your lordship. Paragraph number 6. Be that as it may, in the facts and circumstances of this case, I do not like to go to that extent, but I hope and trust that the Commissioner Excise Government of Assam shall do the needful with regard to this as stated above within a period of 1 month from date of receipt of this order. The Commissioner Excise, on being requested by the petitioner, shall show the whole select list of the petitioner and shall also tell him the names of the other person appointed from the select list and give the complete list of the persons so that the petitioner may be satisfied that no injury or prejudice was caused to him. This is necessary in order to maintain transparency in the field of public employment. The petitioner shall obtain.
So earlier they made appointments without
following
the select list. Where is the merit list?
The merit list, your lordship, is at Annexure C, your lordship, page 34. Page 34, your lordship. The merit list was never published.
And where are which are your clients' serial
50,
number?
Your lordship would kindly come to the next page. 57, serial number 57. Jyotipran Kumar is the petition number 1. Serial number 50, Arun Kumar Das is the petition number 2. And 56 is Hare Krishna Kumar, petition number 3.
So they were not appointed.
They were not appointed in due course, your lordship. They have to be appointed only after the honorable court directed the respondent number 2 to show them the select list and to cater to their grievance.
So you are claiming seniority over those persons?
Yes, who are
who are
appointed
below you in the merit
Yes,
list?
yes, your lordship.
That's your case.
That's the only case, your lordship. In fact, the rules also stipulate. The rules have appended the rules, your lordship, but if your lordship seeks a copy of the rules.
My lord,
He also says something. Rule 17, your lordship. If your lordship kindly comes to rule 17 for a moment, your lordship.
Yes.
Yes, rule 17 appointment subject to the provisions of sub-rule 6 of rule 6, sub-rules 4 of rule 7, sub-rule 5 of rule 14 and sub-rule 7 of rule 14. All appointments shall be made by the appointing authority from the select list with the order of preference, which was not done. And the eventual seniority list was decided on the date of appointment. In fact, the impugned order.
Who is appearing for the private respondent?
Kane's Chaudhary and Mr. My lord, Kane Chaudhary, my lord, assisted by Mr. P.P. Medhi was there, my lord. Today he is not there.
All right, we'll finish it up. No
On
adjournment.
14th of November 2022. The matter was fixed as part heard. This honorable court had gone into in detail.
So well, my only anxiety is that since the order which High Court orders, Honorable High Court orders, which appointed them, my lord, they were
High
silent.
Court order did not appoint them. First, have your rhetorics right.
My lord.
You should have appointed them as per the
My-
select list.
Now-
You did not do it.
My-
High Court came down on the department
My
and asked to be appointed.
My-
So Rule 21 will not have any application here.
My lord, only anxiety is this, my lord. My affidavit, my lord. My lord, there's a delay, my lord, on the part of the petitioners, my lord, approaching this honorable court. Now, my lord, lot of people have been, my lord, they have they have been bestowed seniority, my lord. Now, at this juncture, my lord, if my lord, they are given out of turn seniority, my lord, this might unsettle a few things, my lord.
Yeah, let it unsettle.
And apart
This is
from
the
that,
wrong. Why did you not appoint them when they were in the select list?
my lord,
Why did you appoint others by ignoring them when they were in the select list?
that aspect, my lord, is
That
not
aspect,
open now, my
you
lord,
let the department sort it out.
my lord.
We are not concerned.
And that part,
Their names were in the select list. You give appointments to others below them. Only when the court came down, then you appointed them. And now you are hiding behind technicalities of rules. Let
it's
it be
not technical,
unsettled.
my lord. Only anxiety is that since March water is flown now, my lord. If this may unsettle a lot
What
of
do we
things, my lord.
do? We
No,
say
my lord,
that you have a right, but will not give you relief.
No, my lord, I also concede to that point. They are entitled for relief, my lord. What is department I'm defending that? At that point of time, it was done, my lord. But what I am on now, my lord, lordship will have to balance this.
What is the balance?
Because my lord, a lot of people have gone beyond them, my lord. And one of the petitioner even, my lord, and as is regards to promotion, my lord, as regards to
Gone beyond them in what sense?
seniority, my lord. Gone
Seniority,
about that.
they'll recast the seniority list. Strictly in terms of the position in the merit list.
But now, my lord,
People who are below the petitioners in the merit list
my lord.
will be given seniority below them. That's the direction we'll issue. You
In that
make
case,
the
my lord,
mess, then now
in that
you-
case, my lord, let the petitioners be hard, my private parties be hard, my lord.
they are not here. What to do? Their names
Lordship,
are not.
Lordship, may fix a date, my lord, and because, my lord,
Mr. Gogoi,
only-
this top of the list matters will not be adjourned except for a medical emergency. Nobody. Whoever comes, it will not be.
I understand that, my lord, but
These
I'm-
matters are listed.
I'm
for that.
conceding, but what has happened, my lord, if lordship interferes, I'm conceding he has a good case, my lord, but these people will be, my lord, they will be aggrieved, my lord. If lordship will hear them also once. Otherwise,
No, they're
because
not
I'm
here.
not representing them, my lord, so I'm just representing the department and
They're
my
not
admitting
here.
department has done some wrong.
They are not here.
Because if we go by the honorable court's order, court order is very specifically clear that order of merit will be maintained. Though we have taken a stand that you didn't join at that time, it does not condone. I know that, my lord.
You didn't join because you didn't appoint them.
Yes, my lord. That I'm conceding, my lord. That I'm very
What
being
else is
honest.
there?
But since they'll be affected, my lord, let them be heard once.
Who is
If-
stopping them? You call if you have so much of soft corner, you call them.
It's not about,
We
it's
are
not about soft corner,
nobody
my
is
lord.
stopping them from coming. But don't ask the court to wait because the lawyer doesn't want to come and argue. That will not happen in this court. The name is shown. the
Name is
counsel,
shown, madam.
Then it is up to them.
I am in dire straits, my lord, because at one point,
All
my
the
lord,
three petitioners belong to
no,
OBC.
one has died, my lord. One has
One
expired.
is, this one, petition number
One has
three.
expired.
This one,
Who has died?
petition number 3, your lordship. Hare Krishna Kumar, your lordship.
Because, my lord, if this is to be interfered with, my lord, 1, 2, 3, 1, 2, 3, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. 16 plus 17, 18, 19, 20, 21, 39. Almost 50%, my lord. If lordship takes up the list, my learned friend has produced at page 34, my lord, that's seniority list. Had been 2-3%, my lord, I could have gone to take the burden, my lord.
Yes.
And also as regards my lord, appointing them as a inspectors with my lord, that consequent seniority, we have no objection to that also, my lord. But only anxiety is that these persons will be affected, my lord.
So in the other case, you are challenging the promotion given to the,
Again, lower rank candidates in the selection list, Your Lordship. So if your lordship will only pass an order stating that the seniority will be decided as per the merit list, it serves all my purposes. It serves our purpose. That's the only relief that we're seeking from this court.
Well, I am agreeable to any relief my lord will give them. My lord, only anxiety is let them be hard ones. Because my lord had
them means who?
this my lord, this.
See, I
You
have
are
no
appearing.
instruction from the other parties, lordship, from my clients. I
Sorry?
have no instruction from my client's lordship. There have been, since lordship years, not been contact lordship.
No instruction.
The matter was parted on 14 November 2020.
And where is the select list?
Select
Where is
list?
the gradation list?
The impugned gradation list, Your Lordship?
Yes.
Yes, the impugned gradation list is, Your Lordship, at page 42, Your Lordship. It starts at 42.
Gradation list dated
5/8/2013, Your Lordship, which has been challenged in the first writ petition.
Take down. Heard Mr. M. Sharma, learned counsel appearing for the writ petitioners in both these petitions. Also heard Mr. D. Gogoi, learned standing counsel, Excise Department. Assam.
This be on behalf of Mr. P.N. Goswami. This order, my lord.
Where is Mr. P. L. Goswami?
He's on legs, my lord, on behalf of him.
All right. No, on behalf of either his name or your name.
My name. Then, my lord.
All right. Mr. D. Gogoi, learned standing. Why are you so scared? You
It's
do
not
your
about
job.
scared, my lord. It's not about scared.
your
I know
job.
these people are, these
We
people
are
were.
not here with any vindictive.
This is, I'm not scared, my lord, but since these people are there, my lord, and since,
So they'll catch hold of you outside.
no, they cannot
Once
catch
you
hold
go
of
out,
me.
they'll catch
No,
hold of
no,
you.
they cannot catch hold of me,
Then-
my lord. Lordship is there to protect me.
Why are you scared?
Still there, my lord.
Do your job fearlessly.
My lord.
This is an institution. We have to
Yes, my lord.
act fearlessly
Yes.
and do
Look,
what
I
is
admit, my
right.
lord, they have been wrong. They deserve justice.
Then that's
my lord.
it.
Yes,
You have taken a fair stand. If
Yes.
this institution doesn't, all elements of this institution doesn't act fearlessly, what remains in this country?
yes. Lordship,
Don't be fearful.
that's some
If
other
you think
injury,
it
my
is
lord.
right, it is right. If you
Yes.
think it is wrong,
So-
you argue. Yes. Mr. D. Gogoi, learned standing counsel, Excise Department, Assam, appearing for the official respondents. Mr. DJ Das, learned counsel, is present on behalf of the private respondents.
6, 8 and 21 to 23.
Private respondent numbers 6,
8
8
and 21 to 23.
and 21 to 23 in WPC number
8027.
8027. 8027. None has appeared for the private respondents in WPC number 5481. Right, full stop. Both these writ petitions arise out of, writ petition raises common questions of facts and law, and therefore are being taken up for disposal by these common orders. Full stop. The three writ petitioners herein had participated in the, no, you're right, pursuant to the advertisement notice dated 7/10/1991, issued by the departmental authorities for filling up a number of vacant posts of Assistant Inspector of Excise.
Yes.
The petitioners herein had participated in the selection process and were awaiting positive outcome of the same. However, since the respondent number 2 did not publish the select list till the year 1993, the select list even after completion of the selection process and till the year 1993, and instead went on issuing orders of appointments to candidates without following the order of merit of the selected candidates. The petitioners had, one of the petitioner, namely
Jyoti Pran Kumar.
the petitioner number
1.
1,
Yes.
had approached this court by filing civil rule number 323/1996.
It's 1352 of 1995.
Acha, 1352 of 1995,
Yes.
seeking an order from the court for publication of the select list and the particulars of appointments already made to the post of assistant inspector in terms of the select list. First up, by the order dated 29/2/1996, this court had directed the respondent number 2 to show the select list to the writ petitioner. No, 1352 was filed by how many petitioners?
1352 was filed by petition number 1, 323 was filed by petition number 2, and 1474 was filed by petition number 3. Individual petitions are preferred, Your Lordship.
One three filed by the petitioner 1. Similar writ petitions were filed by the other
Yes.
petitioners as well. That is by the order dated 29/2/1996. This court had directed the respondent number 2 to show the select list to the writ petitioners and issue order of appointments in terms of the select list. First up, the writ petitioners were placed at serial numbers 57, 50, 56, and 57 in the merit list published in the year 1993. First up, therefore, although persons below them in the merit list were already appointed in the post of assistant inspectors, pursuant to the order of this court, the petitioners were appointed as assistant inspectors of excise, in which posts they joined during the period between 1997 and 2000. Full stop. Full stop. However, when the gradation list of assistant inspectors of excise were published on 5/8/2013,
Yes.
they found themselves placed below
Yes.
those candidates who ranked below the petitioners in the merit list published in the year 1993. Aggrieved thereby, the petitioners had submitted representation before the respondent number 2 for correction of the gradation list. However, the representation submitted by the petitioners was rejected by the respondent number 2 by order dated 5/4/2013. And thereafter, the final gradation list, the provisional gradation list was published on 7/3/2012. On the basis of date of joining of the candidates. First of all, I was aggrieved with the persons below them in rank were placed above them. Aggrieved thereby, the petitioners had submitted representation before the respondent number 2 for correction of the gradation list. However, their representations were rejected by order dated 5/4/2013. Whereafter, the final gradation list dated 5/8/2013 was published. Aggrieved by the final gradation list dated 5/8/2013, the instant writ petition has been filed. Full stop. During the pendency of instant writ petition has been filed. During the pendency of this writ petition,
Yes.
as many as 3 assistant inspector of excise were promoted
Yes.
to the post of inspector of excise. As such, the second writ petition, being WPC number 8027/2018, was instituted by the petitioners. Full stop. Be it mentioned herein that during the pendency of these writ petitions, the petitioner number 3, namely
Hare Krishna Kumar.
Sri Hare Krishna Kumar, has expired. Next paragraph. By referring to the provisions of the Assam Subordinate Excise Service Rules, 1990, bracket up hereinafter referred to as the rules of 1990. Mr. Sharma submits that the conditions of service of the petitioners as well as the private respondents are governed by the provisions of the rules of 1990. Full stop. According to Rule 17,
Appointments.
the authorities were duty bound to make appointments from the select list with the order of preference. Full stop. However, in the present case, although the petitioners' names were included in the final select list, no order of appointment was issued in their favor. First up. Subsequently, the appointment orders were issued to the petitioners as per the direction of this court. First up. Therefore, it is not a case that there was delay on their part in joining to join the post of Assistant Inspector of Excise. Under the circumstances, submits Mr. Sharma, Rule 21 of the rules would not have any application in the facts and circumstances of the case. First up, the petitioners' counsel has therefore prayed for an order setting aside the gradation list dated 5/8/2013 and for recasting the same in order of merit in the selection list dated published in the year 1993.
92.
Mr. Gogoi, learned departmental counsel, has submitted in his usual fairness that this is not a case where there was delay on the part of the petitioners' joint duty in terms of their orders of appointment, thereby wiping out their seniority. However, according to Mr. Gogoi, interfering in the matter at this point of time would upset the settled seniority position in the rank of Inspector / Assistant Inspector of Excise, since there has been much delay in the matter. Full stop. Mr. DJ Das, learned counsel appearing for the private respondents, submits that he does not have any instruction to make submissions in the matter and therefore would refrain from advancing any argument on behalf of his clients. Full stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record. Full stop. The facts of the case are more or less admitted. It is not in dispute that the names of the petitioners did find place in the select list published in the year 1992-93 for appointment to the post of Assistant Inspector of Excise. However, for reasons not discernible on the face of the record, no order of appointment was issued in favor of the petitioners, although persons placed below them in the select list were appointed. It was only after directions were issued by this court in connection with Civil Rule number 1352/1995, Civil Rule numbers 323/1996, and Civil Rule number 1474/1998, filed by the petitioners, that orders of appointments were issued in their favor on the basis of inclusion of their names in the merit list published in the year 1993. Full stop. When the gradation list in the cadre of Assistant Inspector of Excise was published, the petitioners found that persons placed below them in the merit list was given seniority above them. Full stop. On being objected, the departmental authorities turned down their objection by relying upon Rule 21 of the rules of 1990, which provides that if a candidate fails to join within 15 days of his appointment, then his seniority would be affected. Full stop. In other words, as per Rule 21, seniority of members of cadre appointed by direct recruitment and by promotion would be determined in accordance to the preference in the respective select lists recommended. If he/she joins within 15 days from the date of receipt of appointment or within the extended period as mentioned in Rule 18, A2 the original requirement of Rule 21. In other words, Agor sentence to Agor. It appears that the departmental authorities were of the opinion that there was delay on the part of the petitioners in joining duty in the post of Assistant Inspector of Excise pursuant to their appointment, and therefore their seniority would stand affected by virtue of Rule 21 of the rules of 1990. However, as noted above, the facts and circumstances of the case indicates otherwise. Full stop. It is certainly not a case where the petitioners had failed to join duty within 15 days of receipt of their order of appointment or within the extended period. Rather, they were denied orders of appointment which were rightfully due to them under the merit list. Full stop. Such being the position, the seniority of the petitioners in order of their merit position in the select list would not have been denied to them by the authorities. Full stop. If persons below the petitioners in the merit list had already joined earlier to them, the same was purely on account of a fortuitous circumstances and not because there was any deficiency on the part of the writ petitioners so as to affect their seniority. Full stop. I therefore find sufficient force in the submission of Mr. Sharma that his clients have been wrongfully denied the seniority in the shadow of Assistant Inspector of Excise as depicted in the gradation list dated 5/8/2013. Full stop. For the reasons stated here and above, the gradation list dated 5/8/2013 insofar as the same relates to the seniority position of all candidates placed below the writ petitioners in the select list of 1993 is hereby interfered with. The respondents are now directed to recast the gradation list of Assistant Inspector of Excise by taking note of the merit position of the candidates, including the writ petitioners herein, by ignoring the delay in joining of the petitioners in their respective posts. Once the process is completed, the gradation list be published afresh. Full stop. The consequential. So these three persons were senior to you in the merit list.
Yes, 57, 50, and 56. Eventually, lower place candidates were appointed.
No, the three persons who were promoted.
Yes.
They were higher than
No,
you.
they were low. They were low. 3, 4, and 5, your lordship. 8027.
They were placed in the merit list.
Lower than us. Lower than the petitioners.
Depending on the outcome of the aforesaid exercise, the authorities would pass appropriate orders governing the claim of promotion of the private respondents in WPC number
8027 of 2018.
8027 of 2018 to the cadre of Inspector of Excise. Full stop. The aforesaid exercise be carried out and completed within a period of 6 weeks from the date of receipt of a certified copy of this order with the above observation. These writ petitions stand disposed of. How many? Two writ petitions.
Two writ petitions.
Disposed of, yes.
All right, sir. I'm grateful to you.
Mr. Gogoi, don't be scared.
I'm not that scared, just another issue, madam. Some different issue.
What issue?
Some different issue. All right, sir.
Yes, what is the
Here
issue?
the challenge was to a disciplinary proceeding being initiated against the petitioner and the consequential speaking order passed by the respondents, by which manner the disciplinary proceeding was directed to be continued.
Just a minute. What is the issue? Petitioner is what? Is serving,
Petitioner is serving, my lord.
serving as?
Now he is serving as the chief engineer, I am told, my lord. At that relevant point of time, he was serving as the executive engineer, non-functional selection grade.
Yes.
The executive engineer civil is the feeder grade to the post of executive engineer non-functional selection grade, my lord. Now, my lord, in the graph, the civil posts are given an equivalence of the to the army ranks. And my lord, the executive engineer non-functional selection grade was given the equivalence of lieutenant colonel. While wearing uniforms, my lord, they are required to wear certain stripes or bands which represent their rank. The allegation against the petitioner is that he was wearing the bands of the rank of lieutenant colonel when he was not required to do so. He was required to wear the badges of a major, rank of major. Now, when the department proceeding was initiated by a memorandum of charge, the petitioner approached this honorable court by filing a writ petition. The honorable court made certain observations directing the respondents to take into account those observations and take a decision whether the disciplinary proceeding needs to be continued or not. They have passed in speaking order continuing the disciplinary proceeding. During the pendency of the writ petition, the disciplinary proceedings had culminated in an inquiry report which had exonerated the petitioner. The disciplinary authority differed with the opinion, gave a show cause notice, and thereafter the punishment of censure has been imposed upon the petitioner at that point of time. Now, if the initiation of the department proceeding, if the petitioner can show that the initiation of the department proceeding was wrong, then perhaps the imposition of the penalty of censure would be wrong. Therefore, although the order of the censure has been brought on record, and the respondents have also admitted that clarification regarding the wearing of badges were issued after the issuance of the memorandum of charge. Therefore, my lord, the petitioner, contention of the petitioner is that the department proceeding was not required to be initiated at that particular point of time. Lordship, Commissioner, I can take through a few documents which will show the stand of the petitioners, my lord.
Just give me 2 minutes.
My lord.
Where is the order of the court, earlier order?
My lord, that starts at page 59, my lord, the effective part. It starts at page 57.
Number of writ petitions.
My petitioners were 3, my lord. There were 3 writ petitioners. 3 different writ petitions raising the same grievance, and they were disposed of by a common order, my lord.
So in page 62, what is this 12th February 2007? As per this notification, it was non-functional selection grade.
Page
Lieutenant
62.
Colonel.
Page 62, my lord, 12 to 2005.
Yes. This
That
was the
lordship-
notification at that point of time.
Yes, my lord. Lordship will find that at page
According to this-
54.
Executive engineers would wear the rank badge of Lieutenant Colonel.
My lord, page 54. Is 12 to 2007. It is by the Ministry of Defense, Corrigendum, New Delhi, 12th of February 2007. My lord, I'll just point out, this was pursuant to a litigation in the Delhi High Court, which was seeking equivalence of the ranks. General Reserve Engineering Force Chief Engineer will be a Major General in the regular army. Superintendent Engineer functional scale will be a Colonel. Executive Engineer non-functional selection grade would be a Lieutenant Colonel.
So at that time, he was executive engineer, non-functional.
My lord.
And
And
he wore the,
Badges of a Lieutenant Colonel. Stand of the respondents is that if lordship will kindly have it page 56.
Hmm.
It's in page 54, madam, page 56. They had issued this continue from page 55. It was a office memorandum by which if lordship will have to lordship's right, lordship will find ranks, engineer services, assistant engineer would be lieutenant, AEE would be captain, EE would be major, then there was a blank lieutenant colonel, and then there was superintendent engineer functional grade of a colonel. They missed out executive engineer
you
non-functional.
are reading from page 55.
Page 56, madam. 56 is a part of page 55. It continues.
Hmm.
Lordship's right ranks, the word is there, my lord, engineer officers. AE would be a lieutenant, AEE would be a captain, EE would be a major, then they keep a blank for lieutenant colonel, then they make superintendent engineer functional grade a colonel. So pursuant to the notification of 12/12/07 by the Ministry of Defense, while the Border Road Organization issues their office memorandum, they keep executive engineer non-functional selection grade blank. They do not give it a rank at page 56. After executive engineer, lordship will find a question mark. They do not put anything there, and then they put on the superintendent engineer. Based on this, they say that since the EE non-functional selection grade was not given the equivalence of lieutenant colonel, the petitioner was wrong in wearing the badge of a lieutenant colonel. Whereas the Ministry of Defense at page 54 had given the equivalence at that point of time. This was discussed in the earlier judgment of this honorable court. That was not taken into consideration also. Coming back to the judgment of this honorable court, my page 70 would be.
So where is the order passed in terms of para 46 of the earlier judgment, not speaking
My lord,
order?
that is at page 79. Page 79, their entire case is dependent upon para 4.1. At point of the relevant paragraphs, 4.1. Then we have para 4.3, the last sub-para on the next page. In the instant case, EE civil non-functional selection grade is a non-functional grade and does not carry a higher position or honor. The post of EE civil NSC does not carry duties and responsibilities of greater importance than those attached to the post of EE civil. The grant of non-functional skill of EE civil does not change the status of law. No additional power is given to so and so. Then they base their case on para 4.9 on the next page.
Then what happened? They went ahead with the
They
department.
went ahead with the department proceeding, my lord. I challenged it by this petition, my lord. Then in the meantime, my lord, the lordship will find at page number So page number 87. They issue a notification of 28/1/2011. That is after the memorandum of charges, where Lordship will find they say, in order to obviate any confusion arising in the past with regard to wearing of uniform and badges of ranks by grave officers, following badges of ranks will be worn by grave officers with immediate effect. Serial number D of the table, they give us the badge of a major. This is what is worn by a major. So they clarify this after issuing me the memorandum of charge.
Yes, there was confusion in this. How can you penalize someone?
Yes, Lordship,
You admit that there was confusion. You were confused. Your department was confused. How can an officer not be confused?
Lordship, but that case is already, now that punishment of censure is there, Lordship. And that is also in the year 2016, Lordship. Thereafter, he was promoted and he had already enjoyed the benefit from promotion, benefit of promotion
Where is
from
the order? Where is the penalty?
Lordship. That is not.
That Lordship in the, it
not
is there in the
there.
additional affidavit, my lord. She says it is not there. It is in the additional affidavit, my lord.
But it is not, not in the.
Which I had filed on 11/8/2006 because it was imposed upon me during pendency of the repetition. It could not be there with the repetition at page 4 of the additional affidavit. 11/8/2016
What is the date?
of the order, my lord, 13 April 2016.
16.
And we brought it on record on 11th of August. The second paragraph, my lord, whereas the charged officer submitted his representation against the above charge memorandum, admitted that he was wearing the unauthorized rank badge but denied the article of charge that he had violated the administrative instruction. Accordingly, inquiry officer and presenting officer were appointed to inquire the charges level against him. In its finding, inquiry officer found the charges level against the CO are not proved. Whereas after considering the finding of the inquiry officer, disciplinary authority disagreed with the findings of the inquiry officer. Accordingly, a disagreement memorandum was issued to the CO. CO have made his submission on 14/4 on the disagreement memorandum and denied the charges leveled against him. Whereas disciplinary authority, after careful consideration of all the points made in the charge officer's submission, the disagreement memorandum and other facts and circumstances of the case has come to the conclusion that the justification put forth by so and so for his defense of wearing the wrong badges have no logical stand. Therefore, charges in Article 1 stand proved. Therefore, the president in exercise of power of so and so.
And what is
conferred
the
upon him.
defense of the petitioner?
That since the equivalence was given with the lieutenant colonel, and there is a finding of this honorable court in the earlier judgment that it was the stand of the respondents, that equivalence is for all practical purposes and not only for the rank. It is recorded in the earlier order also.
Which para?
Para 30.
Para?
He admitted wearing
Para
wrong
35.
in this order.
Yes, but you admitted that you were not sure about which is the correct badge. What happens to his admission then? You said there is confusion, is it not?
Lordship.
Confusion in whose mind? If you are confused, then will the officer not be confused?
The only a minor penalty of censure was there, Lordship. So department, but that has not
So minor
hampered his
penalty.
promotion. He is already promoted. That has not hampered his promotion. Only that wearing of badges, but that has not any effect to this.
All right,
Lordship,
which para?
page
Which para?
77 of the repetition.
Hmm.
Para 44. Fourth line from the top, my lord. The last two words, although it. I'll read the whole paragraph. my lord. The most important aspect of the matter is the Annexure 5 notification dated 12/2/2007, which classifies and places the executive engineer non-functional selection grade to be in the rank of lieutenant colonel, entitling them to put badges of the said rank. In the said notification, there is no post of SE civil. Although it was contended on behalf of the respondents that the said notification prescribing the equivalence of the post was only for the purpose of the Army Act, but the own stand of the respondents before this court in the proceeding involved in the order dated 13/2/2007, by which the repetition was disposed of, will belie the same. By the said order on the basis of the stand of the respondent, this court has held that the equivalence of the post is for all practical purposes and not for the purposes of the Army Act law.
All right. Yes, what do you have to say?
Lordship, the rank and badges are necessary for the department because of its unique structure, functioning and working deployment, Lordship. So it is impractical or illogical to create rank and badges for non-existing physical post in the department, Lordship. Accordingly, the department has already laid down rank and badges for different rank, Lordship, and one has to follow that, Lordship, to maintain the decorum of the department, Lordship. And here he had already admitted that he had were wrong badge, Lordship. That he had admitted.
That's right, but according to him, that was the badge he was entitled to wear, as per the notification of Ministry of Defense. Wrong badge, you are saying it is wrong badge. He is not saying it is wrong badge. He says, according to him, this is the badge you were, and there are 3 officers
Lordship.
doing the same thing.
Lordship,
think-
there are 3 officers had preferred 3 separate writ petition. That 2 Lordship on Monday, Lordship dismissed because they are none representing the petitioner. That was dismissed for non-prosecution, Lordship.
I was not present.
Lordship.
Restoration of the report from a letter. If they agree.
All right, take down, heard Mr. R. Majumdar, learned counsel appearing for the writ petitioner. Also heard Ms. B. Sharma, learned CGC appearing for the respondents. Full stop. Agreed by the order dated 13/4/2016, issued by the respondent number.
That is respondent number 5.
Issued by the Under Secretary to the Government of India, Ministry of Defense, imposing the minor penalty of censure upon the petitioner. As-
13/4 was during the pendency of the petition.
What are you agreeing?
My grievance was the initiation of the disciplinary proceeding, my lord.
Aggrieved by the initiation of disciplinary proceeding against the writ petitioner
Page 21, my lord.
It's not amended also, Lordship, prayer portion.
for wearing wrong RANK BADG rank badge in courts while he was serving as executive engineer from a non-functional grade. It is called non-functional.
Selection grade, non-functional selection, NFSG.
Non-functional selection grade, bracket NFSG. The instant writ petition has been filed. During the pendency of this writ petition, the respondents have completed the disciplinary proceeding. Whereafter, the Under Secretary to the Government of India from a Ministry of Defense had issued the order dated 13/4/2016, imposing the minor penalty of censure within court censure upon the petitioner. Full stop. The order dated 13/4/2016 had been brought on record by filing additional affidavit. Full stop. The facts of the case, in a nutshell, are that the writ petitioner was originally appointed as Assistant Executive Engineer bracket Civil under the Border Roads Organization. Full stop. He was subsequently promoted to the higher ranks, and at present the petitioner is holding the post of Chief Engineer. Is it Chief Engineer Civil or anything?
But the chief engineer civil matter.
Chief Engineer Civil under the BRO. Full stop. While serving as Executive Engineer NFSG. The petitioners, along with 2 other colleagues, namely Sri
Sandeep Singh.
petitioner is Sandeep Singh.
No,
No.
the petitioner is Umashankar.
Namely, Sri Sandeep Singh and Sri Sunil Chandra Srivastava were found wearing the rank badge of Lieutenant Colonel. Full stop. According to the respondents, the petitioner was not entitled to wear the rank badge of Lieutenant Colonel. Full stop. Lieutenant Colonel, and therefore he had committed a misconduct, which was for which he was liable to be proceeded against. Full stop. Consequently, a memorandum of charge dated
15 December 2009.
15 December 2009. Which page is it?
Well, that will be page number 89. 90, madam. I'm sorry.
15/12/2009 was served upon the petitioner, calling upon him to furnish his reply. The memorandum dated 15/12/2009 had contained the article of charge as annexure 1. Full stop. On receipt of the memorandum of charge, the petitioner had approached this court by filing WPC number
1124 of 2010.
1124/2010, inter alia contending that the disciplinary proceeding initiated against him was not maintainable in the eye of law. Full stop. His two other colleagues, namely Sri Sandeep Singh and Sri Sunil Chandra Srivastava, had also received similar memorandum of charges, which had prompted them to approach, which had also prompted them to approach this court by filing WPC number 1121/2010 and WPC number 1146/2010 respectively. Full stop. These three writ petitions were taken up for disposal by a common order. Full stop. The learned single judge had passed judgment and order dated 01/10/2010, disposing of all the three writ petitions with a direction, with the following directions. Page 46 and 40, para 46 and 47, page 78. Full stop. In terms of the order dated 1/10/2010, a speaking order was passed by the respondents, thereby reiterating its stand that the disciplinary proceeding initiated against the writ petitioner and his other colleagues were maintainable in the eye of law. Thereafter, an inquiry officer was appointed and the inquiry proceeding had commenced. Full stop. On completion of the inquiry proceeding, the inquiry officer was of the view that the charge brought against the delinquent officer was not proved. Full stop. However, instead of accepting the findings of the inquiry officer, the disciplinary authority disagreed with the inquiry officer and issued a disagreement memo to the petitioner. First step, the writ petitioner submitted his reply dated 14/4/2015, denying the allegations brought against him. Notwithstanding the same, by the order dated 13/4/2016, the 16, in exercise of powers conferred under Rule 12 of powers conferred upon the President under Rule 12 of CCS bracket CC and A bracket close rules, 1965, minor penalty of censure was imposed upon the petitioner. Full stop. Mr. Majumdar has invited the attention of this court to the notification dated 12/2/2007, as well as the findings recorded in the judgment and order dated 1/10/2010, passed in WPC number 1124 of 2010 and the connected writ petitions to argue that as per the notification of the Ministry of Defense, Executive Engineer NFSG was entitled to wear the badge of Lieutenant Colonel. Full stop. Mr. Majumdar has further pointed out that due to omission on the part of the BRO to specify the badge applicable for Executive Engineer NFSG in the notification dated. What is the date of this
This
notification?
notification, it is not, there, it's BR00 number 3 of 97 at page 55.
Notification bearing BR00 number 03/1997. There was confusion amongst the ranks in the BRO as regards the correct badge to be worn. And taking note of such confusion, the respondent authorities have themselves issued the notification dated notification bearing number BR00 01/2011, whereby it was provided that the badge for the rank of Executive Engineer NFSG would be that of a
Major.
major. However, the aforesaid notification was issued during the pendency of the departmental proceeding initiated against the petitioner. First of, therefore, the said notification could not have been applied retrospectively to cover the case of the writ petitioner. First of, it is also the submission of Mr. Majumdar that although the disciplinary authority had disagreed with the findings of the inquiry officer, no cogent reason has been recorded for adopting such an approach. Full stop. Contending that the petitioner has already got the promotion to the rank of chief engineer, but the penalty of censure is a stigma in his track record. Mr. Majumdar submits that the interim order is liable to be set aside by this court. Opposing the prayer made in the writ petition, Ms. Sharma, learned CGC, has argued that the petitioner has himself admitted of having wearing the rank badge of Lieutenant Colonel, which was beyond his competence, and therefore the respondents were justified not only in initiating the disciplinary proceeding, but also in imposing the penalty by disagreeing with the findings of the inquiry officer. Ms. Sharma further submits that since the writ petitioner has already got the promotions which were due to him, the prayer made in the writ petition is no longer relevant, and therefore the writ petition itself is liable to be closed with such an observation. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. The only issue arising in this case is as to whether the order of penalty issued on 13/4/2016 by disagreeing with the findings of the inquiry officer is valid in the eye of law or not. Full stop. The aforesaid issue would have to be considered in the backdrop of the contentions of the parties outlined herein above. Full stop. At the very outset, it is to be noted herein that there is already a corriendum dated 12/2/2007 issued by the Ministry of Defense, whereby the comparison of rank badge to be worn by GREF engineers with that of the regular army has been laid down. The table appearing in the notification dated 12/7/2000 12/2/2007 is reproduced herein below for ready reference in page 54. Full stop. The question as to whether the said criteria would be applicable throughout the applicable in case of all equivalent posts fell for consideration before the learned single judge. Full stop. By learned single judge, wherein it has been observed in para 44 of the judgment and order dated 1/10/2010 as follows. Extract para 44 in page 77. Full stop. Full stop. That apart, the perusal of the notification bearing number BR0001/2011 itself goes to show that even the authorities were aware that there was some confusion as regards the rank badges to be worn by the GRF officers, and in order to dispel any doubt in the matter, such notification was issued by the authorities. Full stop. It was only in the notification dated BR0001/2011 that it was laid down for the first time the badge that the executive engineer NFSG is entitled to wear. Full stop. Although an earlier notification of similar nature bearing BR0003/97 was issued by the department, in the said notification, no indication was given as to the rank badge that executive engineer NFSG was entitled to wear. Full stop. It is also to be noted herein that at the relevant point of time, it was not only the petitioner, but two other officers of the same rank who had who were found to have been wearing similar kind of badge, thereby indicating that it was not only the petitioner, but there are other officers in the department who, out of some confusion, were wearing such a badge. Full stop. The aforesaid facts, when viewed in the light of the facts and circumstances of this case, gives a clear indication that the notifications holding the field at the relevant point of time were at least capable of dual interpretation by the officers, thereby giving them an impression that the rank badge of Lieutenant Colonel could be worn by the executive engineer. First of all, in other words, it cannot be said that with a deliberate intention of violating the protocol of wearing the rank badge, the writ petitioner had chosen to wear a badge beyond his competence. First of all, there is nothing on record to indicate such an attitude on the part of the petitioner. Full stop. Therefore, even assuming that the petitioner had worn a badge which he was not entitled to wear at the relevant point of time, the same, in the opinion of this court, appears to be a bona fide mistake based on the various circulars holding the field at the relevant point of time. First up, a mistake committed due to confusion arising out of misreading of various conflicting circulars cannot, in the opinion of this court, give rise to any form of misconduct, far less in the nature indicated in the memorandum of charge dated 15/12/2009. Full stop. Situated thus, this court is of the unhesitant opinion that there was no justifiable ground for the disciplinary authority to disagree with the finding of the inquiry officer and reverse his findings so as to impose the penalty of censure upon the petitioner. Full stop. Any order of penalty, it may be noted, appears as a stigma in the service record of an officer. Therefore, unless there are valid and justifiable grounds to sustain imposition of such penalty, the same cannot pass the test of scrutiny by the court of law. Full stop. For the reasons stated herein above, the order of penalty dated so and so is found to be unsustainable in law. The same is accordingly set aside.
I'm obliged.
The parties,
Really, my lord.
1 minute. Which is the order? Let us see the order.
The order is at page number 54 of the writ petition, first writ petition, item number 5, my lord. The relevant portion is at page number 56, my lord.
Yes,
May I read, my lord?
yes.
Paragraph 6, as there is a provision of law for relaxation of upper age limit, we require the petitioners to file individual representations before the head of the department, that is Animal Husbandry and Veterinary Department, giving their own individual reasons as to why the respective upper age limit should be condoned. Upon such individual representations being made for relaxation of upper age limit, the head of the department, that is the commissioner, shall pass individual reasoned orders within a period of 15 days from the date of receipt of such individual representations. The writ petition is disposed as indicated above, my lord. On the
And
basis,
on what basis, what is the finding in the, what is the recording in the order?
my lord,
Where is the speaking order? Which page?
61, my lord. My lord, their representation is at page 57, annexure I, my lord. My
So
lord,
at page 61, the views of the personnel department has been reiterated.
reiterated,
Yes.
my lord.
Who is present before the court? Yes,
My
please
lord.
come forward.
Secretary, Animal Husbandry
Yes.
Department.
No, you saw the earlier order of the court. The
Yes,
same
my lord.
reason was given not to consider.
Yes, my lord, but we have gone through the 1951 circular also,
Yes,
getting the individual representation from Niti Patwari and Lakshmi Bora. But there was no contention, my lord, apart from age, their qualification, and the fact that 5 years have gone by. I have a submission to make, my lord. On perusal, we have seen that Miss Patwari had graduated in 2007 and Miss Bora on 2008.
no, Mr. You are Mr.
Abhijit Bora, sir.
Mr. Borua, we are on a very pointed query.
Yes,
Please answer that.
sir.
These people had earlier come to the court, being aggrieved by the opinion of the personnel department
Sir.
that the upper age limit so and so, so and so, so and so, and there is no further provision of giving age relaxation.
Yes, Honor.
This court, the learned single judge had passed an order dated 2022,
Yes, ma'am.
saying that this view is not correct. Therefore, the matter is to be reconsidered afresh on the basis of individual reasons to be given.
Yes, ma'am.
You have reconsidered the matter
We have.
and then you have rejected it by giving the same quote. You have just extracted the same quotation.
A
So
submission.
what is the point in having a high court order then?
I have, sir, to make this, this contentions were the same, therefore the orders were the same. We are ready to reconsider it, my lord, if specific reason is given in the application for which the condonation of age should be relaxed.
No, there was no reason given in the.
No, my lord. No, my lord, may kindly come to page number 57.
Hmm.
Annexure I, my lord.
Hmm.
That's the representation in both the writ petitions, except the last paragraph, that is the educational qualification and date of acquiring of the degree and the date of birth. Other all the contentions are same, my lord. No special contentions, no special reason for relaxing their age is given in any of the.
So that should have been the answer, that no reason
lord.
has been given.
No reason has.
Instead
been
of doing that, you reiterate the same thing which the High Court earlier said is not acceptable.
I beg your pardon.
Huh?
That was a mistake. I agree, sir. That should have been stated. Your Honor.
You were asked to decide the representation, or you say that we don't find any justifiable ground. But you
Yes,
are straight away quoting the earlier thing and then disposing it off, which is what the single judge said is not acceptable. This is not acceptable, Mr. Barua. You are an IS officer.
Yes, ma'am.
What is the court supposed to do? You tell us, when an officer behaves in this manner, what is the correct recourse for the court? You tell us. You belong to the administrative service, Indian administration. You tell us. Do you think it is correct? Do you think what you have done was correct?
Actually, the order had some infirmities. I agree.
Order had some?
Infirmities, sir.
Now, what do you propose to do?
We will reconsider if my lordship agrees. We'll reconsider again examine and pass speaking order.
My lord, in this matter, lordship kindly consider that my lord, in pursuant to the interim order passed by this honorable court, we appeared before the interview. And accordingly, my lord, one of the candidates, maybe one of the candidates also selected and her result has been withheld, my lord. So that part should be considered by the respondent authority. Because my lord.
So you want the same representation to be reconsidered, or you want to file a fresh?
You know, lordship directed to file one fresh application, my lord. Representation, we may file, my lord. And my lord,
Take down. Heard Mr. A. Sharma, A.K. Sharma, counsel for the lead petitioner. Also heard Ms. M.M. Kotoki, learned standing counsel, Agriculture Department, appearing for the official respondents. Mr. You are there? Mr. Dean, learned senior government advocate Assam is present for respond numbers 1 and 2. Mr. T.J. Mohanty, learned senior counsel, assisted by Ms. P. Sharma, is present on behalf of respond numbers 4 and 5. In terms of the order dated 31/5/2023 passed by this court, Sri Abhijit Borua, IAS, Deputy Secretary to the Government of Assam.
Secretary, sir.
My lord,
Secretary to the Government of Assam. Animal Husbandry and Veterinary Department has appeared personally before this court so as to explain the logic behind issuing a speaking order dated 11/4/2023, which was on the face of it in conflict with the directions issued by the order dated 20/12/2022, passed in WPC number 5350/2022. Responding to a specific query of this court, Mr. Borua has admitted that the order was not couched, the speaking order was not couched in proper language, and therefore, by tendering his apology for the lapses, the departmental secretary has assured this court that a fresh consideration of a representation of the petitioner will be made on the basis of facts, peculiar facts projected before the department, full stop. At this stage, Mr. Sharma also submits that his client be given 7 days time to furnish a fresh representation. In view of the stand taken by the departmental authority as and as agreed to by petitioner's counsel, the speaking order dated so and so is hereby 11/4/2023 is hereby set aside as being contrary to the direction issued by this court by order dated 2012/2022. The petitioner is granted a week's time from today to file a fresh representation seeking age relaxation. If such a representation is submitted within 7 days from today, by enclosing a copy of this order, the departmental secretary shall consider the same on its own merit and give a reasoned order within 10 days thereafter. With the above observation, writ petition stands disposed of. What is the other writ petition?
Same one.
Same, my lord.
Same order in the other writ petition.
My lord, I'm appearing for respondent number 2, Animal Husbandry and Veterinary Department, my
Sorry,
lord.
Animal husbandry and veterinary department, not agriculture. Yes,
Specifically, my lord, as per notification dated 3/5/1950.
that is for him. Again, if it does, then it will happen, then we are this time going to. Mr. Borua, please be a little careful. We understand you all are busy, but don't let these things happen. This is showing that we don't care for a court order. That's not correct. Don't do it. Please don't do it again. Should we take it that you'll be more careful in future? Can we take
I'll
it?
be careful.
All right.
Deeply obliged.
May it please, my lords.
Yes.
In accordance with the order of this honorable court, I have filed my affidavit stating who had informed me as to how that there is going to be a fresh advertisement for the post of Gambura.
Most probably, Lordship, the writ petition has become infrastructure as because Lordship advertisement has already been issued.
Lordship.
Press advertisement.
Lordship, I had participated fairly, your lordship, and the person who was selected did not have the eligibility requirement, your lordship.
That is why.
That this writ petition, we cannot go into that aspect. Here your grievance is something.
Lordship, that is why I had
The Lordship, some false document he has submitted, accordingly his candidature was cancelled. Because of that, this new advertisement.
So your grievance is redressed.
Lordship, now my apprehension is that the person who was selected, in the meantime, he acquired land. So he acquired the eligibility, your lordship. So my apprehension is that that person would again be selected, your lordship.
Maybe then it is entitled to. What is wrong about it?
But my lord, all the other candidates who had participated fairly, your lordship, should have been given a consideration after his selection was rejected.
No, they have cancelled the selection process.
Lordship, pending my appeal, they cancel the selection process, your lordship. So that is why I was praying that.
Come again if you make out a case. We can't get into all these microscopic fights. We can't get into that. The selection process has been cancelled because of whatever reason. So now what remains? Fresh advertisement has been issued.
Lordship, I came second, your lordship. And the person who was selected, he did not, she should not have been considered itself, your lordship. He should not
Why have you cancelled the selection?
Lordship. It's I have obtained the instructions today morning. It's a Lordship in WhatsApp, Lordship. I have got that instruction. That is the minute of the meeting. Why it was rejected? That's because there was no waiting list, Lordship. Only the selected candidate list was there. And that person has, because he has submitted false document, according to this candidature rejected. That is the minute, Lordship.
All right, take on heard Mr. S. Day, learned counsel for the writ petitioner. Also heard Mr. H. Sharma, learned additional senior government advocate Assam, appearing for the respondent numbers 2 and 3. Mr. S. Datta, learned SC.
For respondent number 1.
Revenue Department has appeared for respondent number 1. Full stop. The petitioner is agreed by selection of the respondent number 4 for appointment as Gaubura of village number 1, Bokanadi, and number 2, Bokanadi. Number of Gauburas, is it? You are challenging only number 4.
Yes, your lordship.
Only one.
3 villages.
Village number 1, Bokanadi. On the ground that he did not meet the eligibility requirement under the advertisement notice. Full stop. Responding to the order dated 02/06/2023 passed by this court, Mr. Sharma has produced written instruction to submit that the earlier selection process has been cancelled, whereafter a fresh advertisement has been issued.
On 12/6.
On
12/6, last page, Lord.
2023. First off, Mr. Dey submits that by issuing a fresh advertisement, the respondents would now try to bring the same candidate, that is the respondent number 4, as Gaubara, by giving him an opportunity to acquire the eligibility criteria in the meantime. First off.
He has already done that, my lord. I have submitted the land.
Therefore, Mr. Dey submits that the process is vitiated by malafide. Be that as it may, since a fresh advertisement has already been issued, unless the process is completed and the outcome is known, the plea taken by the petitioner's counsel cannot be accepted at this stage. More so, in view of the reason recorded in the minutes dated 9/4/2023, citing reasons for cancellation of the earlier process, which is found to be justifiable in the facts of the case. As such, by granting leave to the petitioner to approach this court. Now, before that, right, once the selection process is cancelled due to want of candidate in the select list, no writ of mandamus can be issued in the present proceeding to appoint any other candidate whose name is not included in the select list. Stop. As such, by granting liberty to the petitioner to approach this court once again, if he continues to remain aggrieved in the matter, this writ petition stands closed. The written instruction dated the minutes of the meeting dated 9/4/2023 be retained in the record of the case.
As well as the advertisement also.
As well as the advertisement dated
12/6/2023.
Yes. You come again
Much
by
obliged.
making a proper case. Huh?
Lordship.
These are all figments at the moment.
Lordship.
It is not a full-blown case.
Lordship.
Some suspicion is there,
Lordship.
but you have to translate it into a proper case.
Lordship.
Yes. Next matter.
Much obliged.
May I please, Lordship?
Yes.
On earlier occasion, court directed to obtain instruction, Lordship. That instruction not received, Lordship. Kindly one on accommodation, Lordship.
Ms. G. Swami, land counsel with petitioner present, petitioners is present. On the request of Mr. H. Chakravarti, landed government advocate Assam, this matter stands adjourned for 1 week so as to enable him to obtain instruction. This problem. Yes.
Please, Lordship, my lord, petitioner is differently able person with benchmark disability, my lord. He applied for, my lord, grade 4 post pursuant to an advertisement passed by this government, my lord, government of Assam. Thereafter, my lord, a notice was issued, my lord, to appear before medical board. My lord, that is against the provision of the law, my lord. And my lord, kindly see page 31. Annexure G, page 31. 3, my lord, 1, 2, 3. In case of PWBD category, appointment shall be confirmed after medical examination and clearance received from medical board. My lord, in
So what is now today, right now, notice?
yes, my lord, that's my lord, kindly see one thing, my lord.
He is agreed by what? Petitioner is agreed by what?
Medical, this medical, my lord, for medical.
Petitioner is agreed by medical.
Yes, my lord.
What medical?
It should not, medically, he is already, my lord, it is proved. Permanent certificate is
He
there.
should not have been called.
Just a minute, what does he want? Can you tell
Lordship,
me?
he should not have been called to this board, it seems. But he was called, Lordship, when he
Yes.
appeared 207 serial number, his name was there. If he participated, Lordship, then
You have already gone there.
I was constrained, my lord, to go there.
Sorry?
I was constrained to go there, my lord. My lord,
So now, how can we stop you from going there?
he
My
went.
lord, my lord, can you see page 31? 31, similar in case of PWBD.
So what is the
category,
problem?
Appointment, my lord.
Now that you have gone, what is the problem? You have already gone.
Yes, my lord.
Then what is the
But
problem?
problem is, my lord, PWBD appointment shall be confirmed after medical examination. Again,
Yes.
medical examination, my lord.
No, Lordship.
No.
So many days, as per my lord.
Medical
Rule
examination
18.
will be there because you are claiming under the physically disabled category.
Yes, that's
So if you are declined, then only you can come to the court.
yes, Lordship.
At this stage, this is premature.
My lord, but kindly see my lord, rule 18, rule 18 of the right of persons with disabilities rules 2017. Sub-rule 3.
You obtain instruction, we'll take it on Monday, what is happening. Mr. R.S. Chauhan, counsel for the petitioner, there was the statements will be made in the writ petition. The petitioner is aggrieved due to the fact that he has been asked to appear before a medical board pursuant to his candidature for appointment in a post reserved for.
Lordship.
What is this?
Appointment will be done by the secondary education department.
Pursuant to a post reserved for being filled up by persons with physical disability.
Yes, PWD.
Mr. D. Upamanya, learned Standing Council Health Department, Assam, 6 time till Monday, next Monday, to obtain instruction and appraise this court as to whether the process followed in this case is in accordance with law. One extra copy of the writ petition be furnished to Mr. Upamanya. This matter will be posted for motion again on Monday.
Obliged, Lordship.
19th.
Maybe it may be taken after some time because I have not gone through the
You
Mr.
have not
Das.
gone
Mr.
through
Yes, Mr. Das is another court, Lordship.
Oh, okay.
After something.
May I please, Your Lordship? My lord, in this case, petitioner was selected for the post of Graupadan, my lord. My lord, kindly see page 18, my lord. The list was published by notification dated 3/1/2023, my lord.
You obtain instruction
Lordship.
2 weeks after. 2
Lordship.
weeks. I heard Mr. A.H. Amar Chaudhary, learned counsel for the petitioner. The case of the petitioner is that although he was selected for appointment as Gram Pradhan in respect of charge number 10 of Mandia Moja under Bagbor Revenue Circle, more than 5 months back, no order of appointment has been issued in his favor till today, whereas other selected candidates have already been appointed. Mr. S. Dattal, Standing Council, Revenue Department, Assam, prays for 2 weeks time to seek instruction. Mr. D. Boral, Government Advocate, Assam, is present and makes a similar request. As such, let this writ petition be listed for motion again after 2 weeks. 1 extra copy each.
Lordship, we have not been supplied a copy of the writ petition, also a name has also been reflected.
Let this matter be listed by, again, by reflecting the name of learned departmental council in the court list.
May I please, Your Lordship, my lord. My lord, the petitioner was working as Asha worker, my lord, in Jiumari Sub-Center, my lord, under Rupohi Model Hospital, my lord. She remained absent for 1 month only, my lord. That is from, my lord, 31/5/2020.
Only 1 month.
My lord, because of personal conflict, my lord, in the matrimonial dispute, my lord. Thereafter, my lord, Lordship will kindly have a look at the, my lord, page 36, my lord. My lord, the allegations were leveled against her, my lord, that, and the findings of the, my lord, the SDMO and HO, that is, my lord, subdivision and medical and health officer, some of the
notice at this.
she should be allowed to, my lord, join in the service because no
Without
decision was
asking
taken.
them, without giving them
And
opportunity.
Lordship will kindly have last
Heard
line of
Mr.
the, my
Zaid
lord.
Hamad. Yes.
Zaid Hamad, my lord, last line, my lord, page 36, my lord. He was unable to, my lord, terminate her, my lord. And nobody is working in the
We
court.
cannot pass an ex parte order in this case, Mr. Hamad.
My lord.
If a council is reasonable and
My-
knows the law, will never make that prayer.
My lord, Lordship will kindly consider my interim prayer on the next date, my lord.
Mr. Zaid Hamad,
That observation will, Lordship will kindly make.
The petitioner herein claims that she was engaged as an Asha Karmi. However, due to her absence from duty during the period from 31/5/2022 to 3/7/2022, due to pressing personal reasons, the petitioner has not been allowed to join by duty, nor has she been paid her honorarium. Agreed thereby, the present writ petition has been filed. Issue notice returnable in 4 weeks. Who is appearing for whom?
And
Miss-
for respondent number 3,
Mrs.
And
Sharma,
others
Learned
were-
Standing Council, Health and Family Welfare Department, Assam, has appeared and accepted notice for respondent numbers 1, 2, 4 and 5, and Miss
A Bora for
Learned
3,
Standing Council,
NHM.
NHM, for respondent number 3, as such service of notice is complete in this case. Extra copy of the writ petition is furnished to the Learned Department Council within 3 days from today. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date.
My lord, my higher.
Petitioner hearing challenges is a deputy general manager of the Power Grid Corporation, Milan, and challenges the punishment imposed upon him in a departmental inquiry on the quantum only in this case. Because charges were not of defalcation or other things, Milan. He charges that his wife purchased 2 vehicles and those were not reported by the petitioner in the annual report. That is required under the rules, Milan. And unless their own circular states, Milan, unless there is it is a case of excessive defalcation of money, any arises, then the punishment may be only censured. But in this case, they have got it for made a charge for major punishment.
What is the punishment? What is the penalty?
Penalty is compulsory retirement from service. He is 52-year-old Milord, and that also rule says Milord, unless he is 55, that punishment cannot be imposed.
Where is the order of penalty?
Milord.
Page 73, my lord.
Page
73. Next, sir.
Yes, Milord.
His order is of October 2020.
My lord. Thereafter he appealed, Milord. Then thereafter.
So he has already been sent on compulsory.
My lord, on this date, on the date of return order passed, Milord, on 29/10/2020, he was asked to return. Thereafter, he filed an appeal, statutory appeal. Then there was a review application also. And in the meantime, there were some mishaps in the family. So there was some delay in filing this also.
So at this stage, we can issue notice only.
My lord,
Alright.
at this stage.
Alright. Heard Mr. VP Chalil, Learned Senior Counsel, assisted by Ms. Emroy, and the counsel appearing for the writ petitioner, agreed by the order of penalty of compulsory retirement from service dated 29/10/2020 imposed upon the writ petitioner, as well as the subsequent orders rejecting his statutory appeals as well as revision petition. The instant writ petition has been filed inter alia contending that the facts of the case as well as the departmental rule does not justify issuance of such an order of penalty on the allegations brought against the petitioner. Mr. N.C. Das, Learned Senior Counsel, assisted by Ms. M. Devi, has appeared for, you have for?
The 2 to 4, my lord.
This one numbers 2 to 4. Whereas Mr. P.S. Bhattacharya, Learned Counsel, is present for respondent number 1. The issue raised in the writ petition cannot be decided without the counter affidavits, without the affidavits being filed by the department as such. Should notice of motion returnable in 6 weeks. Since Ms. M. Devi, Mr. Bhattacharya has accepted notice for respondent number 1 and Ms. M. Devi for respondent numbers 2 to 4. Service notice is deemed to be complete in this case. Extra copy will be furnished to the Learned Department Council so as to enable them to obtain instruction and file affidavit.
My lord. Requisition is directed against the action on the part of the authority concerned, my lord, in not disposing of the representation submitted by the petitioner, my lord, before the authority concerned for his transfer, my lord. As the petitioner is facing a threat to his life, my lord, in the Dima Hasso, my lord. That is my representation will be at page 9, my lord, page 26, my lord. By which there was a request was made before the authority concerned. And before that also
and the representation, my lord, to the authority concerned. Because for this, I will take your lordship.
Is this an education bench matter?
Lordship.
Huh?
Education bench matter, Lordship.
Will you have any difficulty if it is sent to the?
No, no,
education?
man.
Or Mr. LC does not senior counsel. I'm a little sensitive about the jurisdiction. So otherwise there is no difficulty. Also heard Miss
Escort.
Learned Counsel appearing for the
Education department.
department who submits that this matter pertains to the education bench and therefore be listed before the appropriate bench. They should verify and list the matter before.
Item 16.
May it please your lordship. My lord, this petitioner earlier approached this honorable court, my lord, but due to some defect in the petition, my lord, I withdrew the same and with liberty I filed it again, my lord. My lord, these petitioners are eligible for the Anganwadi worker, but their candidates were rejected, my lord, on the ground that they are not within the survey area, my lord. My lord, before, my lord, there is no any opportunity has been given, my lord. And that's why, my lord, I have annexed the list, my lord, page 42, lordship. This is the impugn list, my lord. Only stating that they are not within the survey area, my lord.
Page 40?
Page 42, my lord. And excerpt 3.
But you said that you are within the survey area.
Yes, my lord.
Then let them submit representation before whom and they will.
For the director, my lord.
Huh?
For the director, let I.
Heard Mr. Giuddin Learned Counsel appearing for the writ petitioners. Also heard Mr. Azhar Learned additional senior government advocate Assam appearing for the respondents. Full stop. The writ petitioner hearing had submitted their application for appointment as Anganwadi workers stroke helpers under the various Anganwadi centers mentioned in the writ petition. However, their applications were rejected by the notification dated 18/5/2023 by holding that the writ petitioners are not the local residents of the survey area of the respective Anganwadi centers under Dhalpukhuri ICDS project in the district of Hojai. Mr. Giuddin submits that the projection made in the notification dated 18/5/2023 is incorrect. However, since the petitioners were not given an opportunity to furnish proof in their favor to establish that they are in fact local women of survey area of the respective Anganwadi centers, the same has caused serious prejudice to the rights and interests of the petitioners. Full stop. After hearing the submission of the petitioners' counsel, this court finds that the plea raised by the petitioners would require factual inquiry, which is not possible in a writ petition. Therefore, the matter will have to be inquired into by the concerned departmental authorities. Full stop. Mr. Dhar submits that if the petitioners approach the respondent number
2, my lord.
2 by filing appropriate representation, the matter will be looked into. Full stop. In view of the above, and as agreed to by learned counsel for both the sides, this writ petition is being disposed of with the direction and disposed of by granting 10 days time to the petitioners to submit appropriate representation along with relevant documentary proof in support of their claim that they are local residents of the survey areas of the respective Anganwadi centers. If such representation accompanied by a certified copy of this order is filed within 10 days from today, the respondent number 2 may either look into it himself or get an inquiry to be caused in the matter to any person appointed by him, any competent person appointed by him, so as to redress the grievance of the petitioners. Whatever be the outcome of the process, the same be communicated to the petitioners within 4 weeks from the date of receipt of the.
My lord, only one prayer. They should file individual representation, my lord, not in a bunch.
We'll file individual representations by annexing a certified copy of it within 4 weeks thereafter. With the above observation,
My lord, till date, my lord, since there is no appointment has been made, my lord, till date.
I don't know whether this is have come from the.
No, my lord, I have stated. my lord.
no appointment has been made in the meantime, the same shall not be made until completion of the above exercise.
If, my lord, if not made.
My lord, here the petitioners are aggrieved by the, my lord, respondent number two's, my lord, inaction in expressing his view for appointment of the, my lord, promotion of the petitioners to the post of the district sports officer from the cadre of the, my lord, SDSO, which is a subdivisional sports officer. The communication was made, my lord, the mass back, my lord, that is on 21, my lord, annexer, my lord, on 19 to 21. For the view of the, my lord,
Petitioner is working as DSO. This
now we are working as a insert DSO, my lord, but our post is holding the cadre is SDSO, my lord. So this will be regular promotion.
No, we means how many petitioners are there?
It is, my lord, one petitioner is individual. Total 4 petitioners there, my lord. If 21, 23, and 24 also similar.
So what is the relief you are seeking?
Relief, my lord, that our, my lord, the opinion that should be expressed by the personal department so that we can be appointed. And the second one is this, my lord, the government of Assam, my lord, those are coming outside of the BTC. My lord, they have been promoted in spite of violating the rules. That is the mandatory rule is this, the minimum 7 years he have to serve as the SDCO, SDSO. But in case of the state of Assam, all the juniors who were cadred entered in 2017, whereas we are cadred entered in 2012. They have been given the promotion of the regular DSO in the district of all the outside the BTC. But the BTC, those are in borrowed by the BTC service, they have been deprived. This is our case that there should be in the same day that the junior are promoted, we should be considered.
Let me seek instructions on this issue.
Will issue a notice?
Notice may be issued.
So, but the government of Assam is concerned, they have to do this thing because by the BTAC, they have done their part.
He has already.
All right, I heard Mr. Mohanta, P. Mohanta, and Council Commissioner. Mr. Narjari is appearing.
I am assistant, my lord. He is not been recorded, my lord. Be Narjari.
He is assisting you.
No, I am assisting, my lord.
You are assisting.
It is a problem, sir, my lord.
All right. Mr. B.B. Narjari, Learned Senior Counsel, assisted by Mr. P. Mahanta, appearing for the petitioner. Also heard Mr. D. Bora, Learned Government Advocate Assam, as well as Mr. S. Rabha, Learned SC BTC, appearing for the official respondents. First up, the writ petitioner herein is presently serving as District Sports Officer, bracket DSO, bracket close, in charge, and posted at Udalguri. First up, according to the petitioner, he is entitled to be considered for regular promotion to the post of DSO as per Order 11, bracket 5 of the Service Order of 2001. However, the respondent has not taken any action to consider his case, although persons junior to the petitioner have already been promoted to the rank of DSO. First up, Mr. D. Bora as well as Mr. Rabha seeks some time to obtain instruction in the matter. And 6 weeks since Mr. Bora has appeared in accepted notice for respondent numbers
1, 2, and 3.
1, 2, and 3, and Mr. Rabha for respondent numbers 4, 5, and 6. No formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department.
21, 22, and 20 are similar. In only the posting place of posting are different and petitioner name are different.
21, 22, 23.
23.
Where I am applying for PTC also.
Same area of party is same.
My lord, the respondents are same, my lord.
Acha. 21, 22, place of posting is different. Check it from there. All right.
I am for the PTC in 21.
Yes, Miss R.B. Bora.
Yes. Only place of posting are different.
Yes.
This matter relates to compassionate appointment, lordship. The petitioner has applied for compassionate appointment on the date of his father, lordship, and his name has been recommended by the DLC, lordship, and the state level committee rejected the candidature of the petitioner on the ground that the father did not have 3 years service at the time of his death, lordship. And
Disposal, which is the
Your lordship's order at page 68.
68 lordship.
68.
Delay is there, but even then lordship, I will not. Page 68, your lordship's order.
Which item you are referring to?
Item 18.
There is no page 68 here.
Yes.
37, 38, 39 is the last page.
Last two pages.
I think there is some confusion.
This is Mrinal Gandhi Dhar.
No, this is Minabala Sarkar.
Item 18.
19.
Wrong record has come, is it?
It is 19.
Item 19.
Item 19, it was. Huh? It was 19.
It's WBC 337023 Mrinal Gandhi Dhar, that is item 18.
Yeah, it has come as 19. Anyway,
Lordship.
they have switched it.
Lordship.
So what is it?
Page 68 is the lordship order.
Disposal, huh? Not Mr. V. Haldar, Learned Council appearing for the petitioner. Where is the minutes of the SLC?
The minus is the page 28 lordship. And the 11 page is page 30.
Petitioner's name?
Minal Kandit.
One number.
It's number 3 from the.
Also heard Mr. H. Sharma, Learned Additional Senior Government Advocate Assam appearing for the state. The petitioner's father died in harness on 03/12/2015 while serving as station officer in Fire and Emergency Service. First up. Thereafter, he had submitted an application seeking appointment on compassionate ground, which was considered by the district level committee of Hojai. And thereafter,
District level committee Kamrup Metro Lodge.
why have you written Hojai? Kamrup Metro.
Yes,
And thereafter recommended the application of the petitioner by minutes of meetings dated 02/04/2018. Recommended the application of the petitioner for appointment in a grade 3 post on compassionate ground on 02/04/2018. However, in the meeting of the SLC held on 02/04/2019, the petitioner's application was rejected on the ground that at the time of his death, the father of the petitioner had less than 3 years of balance service. The said stand was taken by relying upon clause 1 of the OM dated 01/06/2015. Mr. Haldar submits that by the judgment and order dated
31/2023.
31/2023, the learned single judge passed in which
Passed in WBC number 1646 of
passed in WBC
2020.
number 1646 of 2022. The learned single judge had set aside clause 1 of the OM dated 1/6/2015. Mr. Sharma submits that although the state has preferred an appeal against the judgment dated 31/2023 before the division bench, no interim order has been passed in the said appeal till today. If that be the case, this court is of the opinion that the resolution of the SLC or the petitioner deserves to be set aside and the matter is liable to be remanded back to the SLC for fresh consideration of his application based on the merit of his claim. Ordered accordingly, the resolution dated 2/4/2019 qua the petitioner, resolution of SLC dated 2/4/2019 qua the petitioner is hereby set aside. The matter is remanded back to the SLC for a fresh decision of his application on merit. Read petition stands disposal.
Single base WBC number 1646 of 2021, not 22.
2021.
Item 19.
May I please your lordship?
Yes.
Lordship, the petitioners were working as Bal Sevika and Bal Sahayika under the Social Welfare Department. And they retired in 2020. During the service period that had rendered between 2018 and 2020, they had not been paid their salaries. They retired in 2020.
You will issue notice of this.
Yes,
case.
sir.
You are Mr.
HKJ Ahmed.
Mr. HKJ Ahmed, Learned Counsel has appeared for the petitioner. The read petitioners herein were appointed as Bal Sevika and Bal Sahayaks. First of Bal Sahayaks under the Department of Social Welfare, Government of Assam. They have retired from service, however, aggrieved by non-payment of salaries to honorarium for the period of service rendered by them. The instant writ petition has been filed seeking a writ of mandamus. Mr. D. Bora, Learned Government Advocate Assam, prays for some time to obtain instruction in the matter. Stop. Issue notice of motion returnable in 6 weeks. Since Mr. Bora has appeared in accepted notice on behalf of respondent numbers 1 to 4, no formal notice is required to be sent in this case. Extra copy of the writ petition requisite in numbers be furnished to the Learned Departmental Council.
Obliged.
So as to enable him to obtain instruction.
Obliged.
Maybe in case of the petition has been rejected on the ground of height relaxation, height short in height. Your lordship already granted some relief to file an appeal.
Shorting height.
Yes.
Yes.
Page 63, my lord.
Mr. H.R. Ahmed, Mr. S.S. Roy, page 63. Page 64.
Petition appeared on 6-5 in this case. Instead of 3-5, it will be 6-5.
No, but one post will not give it now.
That's fine.
That part will not give it. You have come late. Single, only sole writ petitioner.
Yes, ma'am.
Disposed of. You get it in page 64. Just see the changes, 1 or 2 changes.
Obliged, ma'am.
May I please the lordship. Lordship, here petitioner is unmarried, lordship, dependent daughters. His father saw died, lordship. Ultimately, lordship, he was applied for a compensatory family pensions as well as this normal family pensions, lordship. And accordingly, lordship, on being considered his dependency part, his pensions amount has been granted, lordship. That is page 62. Lordship, here the petitioner is agreed the amount against the amount part, lordship. There is, lordship, kindly come into serial number 5. Here, lordship, the family pension admissible in C columns, lordship. FP family pensions at rupees.
Family pension has been paid.
No, lordship, not paid.
Granted, lordship.
Granted.
As per his lordship, this page 62, lordship, it is granted.
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 But he is dissatisfied with the amount.
Yes, but you want lordship compassionate family pension.
Yes, lordship. But till date, lordship, that amount, whatever amount has been granted, that amount also not paid, lordship.
All right. Heard Mr. Ihawk, Learned Counsel for the petitioner. The case of the petitioner is that her father had died in harness on 3/11/2019, whereafter compassionate family pension was granted by the department.
By the AG, lordship.
was-
No, normal family pension, lordship.
Compassionate family pension.
Not compassionate, lordship, it is family pension. lordship. No.
Family pension was granted to the dependent family members of the deceased employee. The grievance of the petitioner is on 2 counts. Firstly, that the amount granted is not correct.
Correct.
Secondly, despite granting the family pension.
Lordship,
payment-
in fact, he has challenged this, lordship. He has challenged this page 62, lordship. He is on the one hand, he is saying, lordship, this is not paying. And he has
Despite
challenged.
granting the family pension, no amount has been disbursed till date. Mr. And then Upadhyay Nanad, Standing Council Irrigation Department, prays for some time to obtain instruction. NOM 6 weeks since Mr.
1 and 5, Lordship.
Mr. Upadhyay has accepted notice for respond numbers 1 and 5. Mr. P. Nayak, Learned SC Finance for respond number 2. Mr. A. Chakravarti, Learned Government Advocate Assam for respond number 3, and Mr. M. Hassan. A. Hassan, Learned Council for respond number 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Department Council so as to enable them to obtain instruction. It is made clear that pendency of this writ petition shall not be a bar for the authorities to take appropriate action in the matter in accordance with the
Please.
Please, Your Lordship, here there are two petitioners. They are applying in constable of Central Police Force, Your Lordship. Advertise was published in 21/7/2018. They are from the OBC category.
Is it covered case?
Covered
Page
case.
number?
Yes, I have annexed the order.
Yes, where is the order?
That is in page 69, Your Lordship.
Any order of this court?
Yes, I have.
No, Mr.
You say here.
All OBC, all of them are OBC.
OBC, two petitioners are there.
Yes, disposed of.
Obliged.
Me, please.
But if this matter is a bench for matter, I think.
Mr. B.B. Vora, Learned Counsel for the petitioner submits that this is a matter pertaining to civil bench court, and therefore it has been wrongly listed before this bench. Registry to verify and list the matter for appropriate bench.
May I please, Your Lordship? Lordship, the matter relates to the recruitment of the Central Armed Police Force, Lordship. Where the petitioner's height was decreased by the respondent authorities and mention.
Is it a covered matter?
Yes, Lordship.
Where is the order?
Earlier order, Lordship, finally page 6, page 50, Lordship. I have annexed page 50, Lordship.
But we are not going to give any one post vacant now. That order will not be passed. Mr. N.H. Lashkar, and you are appearing?
For Mrs. A. Gain, Lordship.
Page 51, disposed of. Yes,
Most of it.
Finding motion matter item 10.
Well, in this case, my lord, first time notice may go.
But Mr. H. Das, Learned Counsel for the petitioner, there will be amendment made in the writ petition. NOM 6 weeks since Mr. A. Chakravarti, Learned Government Advocate Assembly, has appeared for respond numbers. All the respondents.
No, 1 to 5, lords. 1 to 5.
1 to 5, no formal notice is required to send in this case. Extra copies of the writ petition be furnished to the Learned Department Council. Petitioner takes steps for service of notice upon respond number 6. By registered post with AD. Since the challenge in this writ petition is to the appointment order dated 25/5/2023, issued in favor of respond number 6, the Learned Department Council to obtain instruction and file affidavit before the return date.
Supplementary list for motion item 55.
May I please?
Well, in this case, my lord, last occasion, I was directed to the police office memorandum, which pertains to the compensation appointment with regard to the invalid pension. I have submitted my lord, 83 office memorandum, my lord, paragraph 9, my lord.
What is the relief you want?
My lord,
What is the
my
relief?
simple pair, my lord, only consider place before the DLC, my lord. This is my pair, my lord. I'm not seeking appointment, my lord, just for placing, my lord. Paragraph 9.
So let the DLC consider if it has not been done already. Yes, but today there is an OM for what? Family pension.
My lord, last occasion, my lord, my father.
The DLC will consider whether it is a case of compassionate appointment or payment of compassionate family.
Yes, for
pension.
office memorandum.
Yes, but Mr. Or Mr. D. Gogoi, learned counsel appearing for the writ petitioner, peruse the statements made in the writ petition. The father of the petitioner died in harness.
Not that, my lord, got invalid pension.
Acha, the father of the petitioner who was working as a khalasi in the office of executive engineer, Nalbari Water Resources Department, had to retire on receiving invalid pension in the year 2001. First up, pursuant thereto, the petitioner had submitted an application dated 02/01/2001 seeking appointment on compassionate ground. First up. However, according to Mr. Gogoi, the application submitted by the petitioner has not been considered till today. Full stop. Agreed thereby, this writ petition has been filed. I find from the materials on record that there has already been substantial delay in the matter. Therefore, at this point of time, it is doubtful as to whether the petitioner's prayer for appointment on compassionate ground would be maintainable in law. Be that as it may, since there is already an application filed by him, this same deserves to be considered by the concerned authorities in accordance with law. Full stop. I therefore dispose of this writ petition with a direction upon the respond number 4 and 5. Respond numbers 4 and 5 to consider the application submitted by the petitioner and pass appropriate order therein. In doing so, the respondents shall also be entitled to consider as to whether this is a fit case for payment of compassionate family pension, and if so, necessary steps be taken in that regard. Writ petition stands disposal. And who is appearing for who?
I am for 4 and 5.
Mr. S.S. Roy, learned counsel for government advocate, appears for respondents 4 and 5, and Mr. R.M. Das for
1, 2, 3.
and standing counsel Water Resources Department for respond numbers 1, 2, 3.
Diplomas.
Give it in the top, yes.
Diplomas.
May the matter be kindly pass over for the timing my seniors on next.
What is this matter?
This matter is regarding disengagement of the contractual employees of ASTC. 771 in the association has come. Let the matter be taken up tomorrow, Lordship. Then.
Lordship at 2, today at 2.
All right, let's see.
Yes.
Second up.
Your lordship. One of the petitioner before your lordship. He is an employee, more particularly, my lord, he is a senior superintendent in the respondent organization. And he appeared in pursuance to, my lord, page 23, circular, my lord. 12/12/2002, my lord, page 23. For
What is
promotion
what
to
is
the next
matter
higher,
about promotion?
for promotion next higher grade through DPC, my lord. Your lordship, the post concerned is assistant register, not all, my lord, only that at serial 1. Senior
So no-
superintendent.
Notice has to go today.
Notice has to go, my lord. Interim, my lord. The Board of Governor, which is the approving authority, they are sitting tomorrow or day after, my lord. I have made a statement here. And once it is approved, my lord, third party rights will improve. IMA
selected candidate at the top of the extended list of the last my lord, internal advertisement. And my lord, normally I should have been given to the additional post that is falling vacant within the vacancy here, but they concealed it. That is the case where they concealed it and they came out with another advertisement. I have represented, and my lord, they say, my lord, their replies also have annexed.
You are appearing for the IIT.
Lordship, my senior friend.
What is your response?
No, Lordship, the facts have not been properly presented.
At two.
Lordship. Approach this honorable court with the same issue. My lord, the board of the Assam State Transport Corporation took a decision to terminate 771 employees working under them. That your lordship will find at page 43, the decision. Annexure 12. Well, your lordship will find that in the review meeting, it was chaired by the members present were noted there. In the review meeting of the Transport Department on 27/6/2022, it was decided to inquire. Your lordship will take note of the word to inquire into the procedure followed in recruitment of contractual staff in ASTC and verify whether due procedure was followed in such recruitment and to retain only the legally appointed staff. Upon verification, it was observed that 771 employees as per Annexure A were appointed without following due procedure, such as newspaper advertisement, etc. A presentation was made in the meeting on the status of contractual employees, and after trade-based discussion, the following decisions were taken. It was observed that ASTC, a government of some undertaking, cannot indulge in appointment which are irregular and illegal. It is also important to maintain roster system giving reservation to various categories like SC, ST, OBC, etc. for recruitment appointments in government and public sector undertaking. Newspaper advertisement and selection procedure in a fair and transparent manner are signed known in government appointments. In the 7071 contractual appointment, ASTC has not followed any procedure as mentioned above. ASTC is solely dependent on the government for meeting the salary requirements of its employees. Any appointment in ASTC should have prior approval of government, as this has financial implication on the side of the government. As such, the contract of the 771 employees who are recruited not following procedure of advertising, etc., will not be renewed, and the person shall be released. As these are not regular appointments and contract agreement has already expired, the non-renewal of contract will be adequate in this case to release the person's portal. Inquiries should also be conducted to fix responsibility for irregular engagement of contractual appointment. In regards of appointment on compassionate ground, Assam government has discontinued the same after April 2017. MD ASTC to conduct detailed inquiry into the appointment in ASTC under the compassionate ground and whether these are in consonance with the government guidelines and submit report thereof. Then, my lord, they have given the chart from page 44 onwards up to 46. Now, your lordship will find the second decision is at page 47. Page 47, Annexure 13.
Yes.
In view of the review meeting held at the conference hall of the Chief Minister on 29/4/2023, wherein it was found that during the appointment, 771 numbers of contractual staffs were in ASTC, later was not followed any was laid down by the government of Assam. Accordingly, it has been placed before the board of directors for release of 771 numbers of contractual employees from the respective services. However, as they are working till date, remuneration may be paid till May 2023. Further, the remaining contractual employees who are rendering their services in ASTC till date and are entitled to get their remuneration up to May 2023. The term of the contractual employees were renewed up to 31st March 2023. We may pay the remuneration to all or to also contractual employee up to May 23rd and extend that term accordingly. Then your lordship will say the matter is placed before the board for necessary approval. Then your lordship will skip that and look into the last paragraph. In view of the direction issued by the government of Assam Transport Department, ASTC has decided to release 770 numbers of contractual employees from their respective services. However, after releasing of the said employees from their respective duties, there will be shortage of manpower in ASTC. Therefore, after threadbare discussion and by looking at the urgency of manpower and security of the office assets, ASTC has decided to hire the services of the casual workers through outsourcing agency, where entire liabilities, including the service benefit of the said workers, will be covered by the manpower agency through whom the said workers will be hired. The only responsibility of the ASTC will be to pay them their monthly salaries through the respective manpower agency. Accordingly, the minimum requirement has been earmarked as per annexure herewith. Then the last paragraph, as per the minutes of the 172nd meeting of the Board of Directors held on 6/6/2000, it was decided to engage additional helping staff like cook, one assistant and sweeper for MD only from the existing staff. However, it was not approved for chairman. Now approval sought for engaging a cook for chairman and vice chairman also. ASTC does not have the cook and adequate staff of its own. This same may be engaged through manpower agency, through outsourcing and so and so. Now they have given this requirement of manpower after release of 771 employees. That starts from page 14. That is at page 49. Then, my lord, the release orders, the consequent release orders are, I'll take your lordship to one such order at page 50. I'll come, my lord. Your lordship will see what this court prima facie held in the one of the cases, my lord. This is the order, my lord. Page number 2. The petitioners are aggrieved by the disengagement as contractual employees, training mechanic from the AST Silchar. This said engagement has been done in terms of a communication dated 35/2023. This is also in our enclosed in our petition as page 50, which has been issued accordance with the 185 meeting of the Board of Directors of the SA Estate held on 24/4/2023, and also minutes of the meeting dated 29/4/2023, page 43 of the AST. The case projected by the petitioner is that though a resolution was taken to disengage all persons who are engaged on contractual basis on fixed pay, there is a further condition that a verification exercise was required to be done to ascertain whether such engagement was done without following any recruitment process. The learned senior counsel for the petitioner submits that without carrying on any such verification process, in a mechanical manner, the names of the petitioners have been included in a list of about 771 persons who have been sought to be released. The learned senior counsel has submitted that the petitioners do not fall within the said category, and therefore the disengagement list could not have contained the names. Reference had been made to a process mooted by the head office of the ASC at Gratuity by communication dated 2/6/2014 to engage ITF pass candidates as a mechanical apprentice after the selection. The learned senior counsel has also referred to the communication involved in the District Employment Exchange Kachar and the ITF Kachar to demonstrate that it was only after a due selection process that the petitioners were engaged as trainee mechanical. He further submits that in such selection, even a representative of the principal ITS Silchar was present. It is also the case of the petitioner that subsequently the documents of the petitioners were taken up for verification in accordance with the ROP rules. Reference has also been made to a communication dated 7/7/2014 issued by the divisional engineer ASTC Silchar to head office forwarding a list of selected candidates, which includes the names of the petitioner. Under those circumstances, prayer made is for interference in case of the petitioners. On the other hand, Sri P. Nayak, learned standing counsel ASTC, has submitted that a conscious decision has been taken to disengage all employees who were engaged on contractual basis and for a fixed term. He submits that so far as petitioners are concerned, the term was not extended. He also submits that there is a specific resolution of the Board of Directors not to extend the terms of such person. The learned standing counsel also submits that there appears to be some discrepancy with the letter dated 2/6/2014, by which a recruitment process was mooted, and the letter dated 13/6/2014 issued by the Silchar office to the employer not changed. Then your lordship may skip those paragraphs of the submission and go to the next page. It appears that the next page, my lord, second last paragraph. It appears that the impugn action of disengagement of the petitioners has been taken on the basis of communication dated 35/2023, that is at page 50. And the resolution dated 29/4/2023, page 43, and 24/5/2023 mentioned in the said notification. However, this court has noted that such disengagement was to be done after the verification regarding the mode of engagement of the incumbents, namely as to whether any recruitment procedure was followed at the time of the engagement. Apart from the fact that such verification process does not appear to have been done, which would otherwise require following the due process, including adherence to the principles of natural justice, the materials on record would do to the contrary to show that the recruitment process was conducted for the petitioners. Then your lordship can say, and the last paragraph, page 5 is, this court is of the opinion that a prima facie case is made out by the petitioner who have been working as so-and-so for the last almost a decade after and so-and-so.
So,
now
Mr.
they say-
Kaur, there is a problem here.
Yes, ma'am.
You will find it technical, but I'll tell you the reason why this problem is going to hit you. Insofar as examining the matter is concerned, if that is what you want, we can issue notice. But if you're asking for interim relief, that order cannot be passed here. That can be passed only when individuals come to the court by seeking an order of protection of their rights. Association cannot get an interim order to continue their members in service.
No,
You can argue on that.
No, madam. I will only go by a different proposal. Your lordship has prima facie seen from the board of resolution that one set of ad hoc employees is now being sought to be replaced by another set of employees to manage it.
That's Mr. Kaur. What I am saying is, yes, if another set comes in, we can examine. We can examine why they are being brought in, whether it conforms to the please.
Yes, yes.
Law laid down in Pyara Singh versus State of Haryana, we'll examine. Correct. And on the touchstone of morality, constitutional morality, if you succeed, the order can be set aside or a direction can be given. But if you want an interim order allowing the petitioners to continue, as in this case, that order cannot be passed in this case.
So my humble prayer before your lordship is that your lordship will distinguish this case from this case. And if the individual petitioners come, then your lordship will look into that observation. Your lordship will may kindly give it. Otherwise, it may they may think that since we have gone with the union, that's why we have not got it. So that option, your lord, because otherwise it will be that as if interim prayer has been rejected. So that because in some cases 3 persons have got because they have filed it individually. Yes, that observation your lordship will get. But your lordship will also protect their interest at page 47, this second paragraph, my lord. Page 47. This they, my lord, will not do because if they want to engage for the time being, persons who are already there, they can take the utilize of those persons who are already working for 10, 15 or 20 years at page 47, the second paragraph. Thereafter.
That is what the court will of course. We'll
Yes,
have to see.
that is one, my lord. And now we are already restricting how I have not taken your lordship to the background under how they were appointed. Your lordship will kindly say I have restricted.
No, we'll examine
Just one document your lordship will see. It's only for your, at this stage, I'm not making
the
it.
court is not making any observation
Yes.
and approval of the decision.
But just your lordship for one cursory glance, your lordship will give.
But the simple reason is that we don't know who are the members, what are their backgrounds, what are their eligibilities.
That option your lordship will keep it open because they can come and get themselves included in this petition by filing a separate IA and all. But this 47 at paragraph number 2, that protection your lordship will give those members because they are the people who are already working for 10, 15 years and now they are trying to bring in another person.
So that will examine. We'll see here. Yes, Mr. Saikya, you are appearing.
As lordship is
And already, just a moment. Already the security people who are guarding the buses and that they have already engaged some new security personnel. Agency. That's the whole tragedy, madam.
Yes.
That is not the tragedy, lordship. That is the solution. Why? Only in respect of the security, we have a panel of agencies, panel under transport department. When we have removed everybody, lordship, there are incidents of theft of the batteries and parts of the vehicles, very expensive vehicles, CNG vehicles. So we, through our agency, which is already panel in transport department. So very few security personnel, just like this Honorable High Court also gives agencies to work to some agencies for the housekeeping part. Identically, they are not employees to us. Or security is also in various government departments also. Security agencies provide the manpower for giving the security chokidars and other person. That is the only issue.
as Lordship is not passing any interim order, I would not make any argument today. If there is urgency, I can file the affidavit by tomorrow afternoon. And Lordship may take up the issue because it's a legal issue. Otherwise, no affidavit is also required.
No, that's correct. But Mr. Saikia, these people working for 10 years, 12 years.
No, it
suddenly-
is not correct. It is not correct. It is not correct, number one. And Lordship will be astonished to see who are the persons employed. Even the office bearers' daughters and sons are the employees here. The office bearer of this association, the ministers, it is nepotism of the highest order. 771 person entered into service. If Lordship looks into it, we have two categories. That verification, the learned single judge made an observation that is not correct in my humble submission. A proper and in verification was done, and I have the file. This process started in June 2022. We obtained every information. I can just place 3 papers that will be suffice.
Right, Mr. Saikia, can you
That's why-
file a preliminary affidavit by Monday? We'll
No,
post
by
it.
tomorrow I can file, and Lordship may take up the matter for final disposal on Tuesday, Friday, if it is convenient to the Honorable Court. Because these 3 person got the interim order, Lordship, there is a direct incorrect factual observations of the learned single judge that there was no verification. There was verification,
that's all
and there
right.
was a detailed verification.
This order was passed by a coordinate bench.
Exactly, Lordship.
In another matter, so this court cannot comment on that.
Absolutely, I'm not, because they are at that point of time, Lordship, if it was not filed also on the very first day that order, that's why I'm submitting. Because if Lordship gets a complete facts, it will be easier to dispose of the case or take a call on the interim order also.
All right.
And unlike in the Assam Fisheries
I
Development.
can distinguish the other
Corporation-
case also.
In Assam Fisheries Development Corporation, where some irregular appointments were taken, they have suspended the managing director, chairman action. Here till now, they have not initiated any criminal action against those persons, even if those appointments are irregular.
No, Mr. Kaur, see, and Mr. Saikia, please hope you will appreciate one aspect. While the court will always be sensitive to some human aspects involved, in this form of sudden termination of service of large number of people. Yet, if the state comes out with prima facie material to show that these are all the products of nepotism, irregularity, and there are bases to say that, the principles of equality will not extend to protect those who have come in through a illegitimate
Yes.
manner. That you will accept. That is the reason.
That's the first limb. The second limb, who is responsible for all those cases? That against those persons
That
who
will
have
come,
become.
that will come later.
Yes.
Are you admitting that somebody is
No,
responsible?
that's why I was restraining myself from enclosing this documents. I kept it.
Don't restrain yourself. Because this is a.
I'll do it.
Do
But
or die situation.
let them file the affidavit in opposition, then I'll bring all those documents.
All right.
These are the people who recommended us for appointment, and these are the people who are the ham of affairs, and now they are saying that we are irregular.
No, that is
This is
another.
not irregular, it is illegal.
That is another aspect of the matter. Even if somebody has recommended, if it is illegal, it's illegal. That will not justify. As the saying goes, 2 wrongs are not going to make a right.
Yeah.
This is a court of equity. As I have mentioned, while the court is always conscious and if necessary will be active in all form to protect human rights, fundamental rights. But people coming in through the back door through a process which is not recognized by law cannot get the benefit of equitable consideration. So some relief which cannot be given finally, we will not give it now.
But
And second aspect is that the association has come against termination of individuals. You know why you did it, but this is going to create a technical problem for the court.
Well, that observation you also repeat.
No, we will not give any observation. We'll only fix it on Monday for you to.
They are filing the affidavit by
Preliminary,
tomorrow.
preliminary.
I'll go through it. If there's some replies required, I'll file it by the next day.
We'll
If the
post it
advocate
on-
general assures that the affidavit will file next day, then I'll also reply it by the next day.
That's what he's saying.
Yes, yes.
We'll file it by when?
If I want to file it by tomorrow, if Lordship is taking up the matter on Monday, then I'll file it on Friday. With an advance copy to him, and the verification report was done in respect of 2,274 employees, out of which 71 were found to be entered into or engaged in by ASCC without any advertisement, without any recruitment process. Rest, we have continued. The remaining about 1,600. So we have done a complete detailed exercise on this.
So people whose appointments have been found to be valid, they have been
They are
continued.
continuing. They are continuing.
Are they part of your association?
Yes.
All employees are there, my lord. I don't have the, I
No,
don't have the.
Mr.
papers.
Kaur, don't laugh.
No, no,
If
I'm
that
not
is the
laughing,
case,
madam.
we'll dismiss this
Yes,
petition.
no, my learned friend will furnish this inquiry report or whatever he is relying. Once I look at it, I'll come with appropriate response, madam. I cannot fire in the dark.
Because if the members of this association, some are protected, some are affected, and you can't espouse the cause of both.
That's
So
why, madam.
66% continuing, 33% removed.
Well, once I have those facts in the
All
form of
right,
evidence,
so
I'll
you,
respond.
you think about it, because ultimately we don't want to put these things in the judgment. Either you have to
I appreciate
satisfy
that.
the court or we'll put it
Yes.
in the judgment. That will create problems.
Yes, madam.
If you think this petition needs to
But
be.
since your
withdrawn-
lordship is hearing it on a Monday, so
All right.
we can.
But Mr. BD.
The other
Kaur,
matter
as
is
a
also
senior
fixed on 26th, madam.
assisted by
P. Gupta.
Ms. P. Gupta and a counsel for the lead petitioner. Also heard Mr. D. Seika, learned Advocate General Assam, assisted by Mr. P. Naik, appearing for the official respondents. Mr. Seika submits that the decision to terminate the services of the seven.
Disengage. We are not terminating. We are
Disengage.
disengage.
The contractual service of the 771 employees of the State Transport Assam State Transport Corporation bracket ASTC was taken after a thorough inquiry was conducted on the question of validity stroke legality of their employment system. On completion of such inquiry, 66%, approximately 66% of the contractual employees have been retained
And they are continuing.
and they are still continuing in service, whereas 33% bracket approx
771.
constituting the 771 workers have been disengaged since their appointments have been found to be completely illegal and the product of nepotism and corrupt practice. First up,
At
since
this stage, my lord, I dispute it, but.
My submission, this is my submission.
submission, since Mr. Saikia has prayed for time till Friday, that is so and so, to file a preliminary affidavit bringing those facts on record. This matter be posted again on Monday, that is 19th, for motion. The affidavit be positively filed on or before, that will be.
By mid 12 noon on Friday.
By-
In the first half, we'll file it.
By 12 noon of 16th of June
16th.
2023 by serving advance copy upon the petitioner's counsel. The read petitioner may file rejoinder if so advised. Let this matter be listed accordingly.
Highly obliged.
19 it is coming, my lord.
19 is fixed item for motion.
My lord, the other matter is tagged or it will come separately.
That
If
is
you
on
want-
26th.
That is on 26.
We are blessed.
Deeply obliged.
My lord, as I was submitting, my lord, the petitioner was recommended by the DPC, my lord, for his promotion, and his name was kept at the reserve list.
Petitioner was recommended by DPC for promotion to.
The next higher grade, my lord,
What is it? What
the
is-
post in question called assistant registrar, my lord. Petitioner is serving as senior superintendent. That your lordship will find, my lord,
Yes.
at page 22. Page 22, your lordship will notice, my lord, there are two lists. I'll just read out, my lord. The board was requested to consider and approve the selection committee report that recommended the following four candidates for the post of assistant registrar unreserved by DPC meeting held on 18/2/2022. So these first four names, they were appointed against four advertised posts of assistant registrar. Now there is a second list at page 22. The committee also recommended the following panel within bracket valid for 1 year. Your lordship will find at serial 5, the petitioner's name.
Yes.
At page
This
20.
panel was prepared when?
This was prepared on 18 to 22, my lord.
So that
DPC
1
meeting.
year has already gone.
No, my lord, the things happen within that. Things happen. I'll just show the documents. And your lordship, below that, my lord, the resolution. Resolved to approve the recommendation of the Department Promotion Committee meeting for selection of 4 candidates, that is the first list, and the panel mentioned above for the post of assistant registrar held on 18 to 2022. Now, my lord, this information was held back for reasons best known to them. This was not uploaded in the website, nor the individually the petitioners have been, the petitioner or the others have been intimated. Be that as it may, my lord, there was another advertisement, my lord. You want it to page?
23.
My lord, annexure B, my lord, page 23. This is for additional vacancy. That first 4 posts were that filled up, my lord. That recommended list remained, my lord, the reserve list that remained. And during the year, your lordship will also see, my lord, 12-12-22. The vacancy here, my lord, they define as 1st of January to 31st of December, as per the rules followed by them. So within the year, another post of assistant registrar fell vacant, and they came with this, my lord, internal advertisement, my lord, for internal candidates, my lord. Now, not knowing that his name was already there, my lord, he had applied. The petitioner had applied for this time also, my lord.
So, Mr. Goswami, what is the relief? What is the
Relief, my lord, at this moment, my your lordship will issue notice, my lord. But the point is, my lord, the board of governors, which is the approving authority, my lord, they are going to approve it. This will be placed, and they are meeting tomorrow or day after.
They are going to approve what?
My lord, the result of this recommendation of the second advertisement. So that may be stayed, or that post may not be filled up. In the meantime, your lordship will call for
No,
it.
if that is stayed, how your clients get to benefit? He may be reflected in that.
No, my lord, I'll be affected, my lord, if that is filled up, my lord. Third party right will accrue, my lord, then. I don't know.
So you want that your client should be appointed on the basis of the
This vacancy,
recommendation?
because this vacancy, my lord, the rule says I have quoted, my lord. Your lordship will kindly come to.
You want that this recommendation of 18 to 2022 be implemented?
Yes, my lord.
That's
First.
not possible.
That is
The
first.
select list is valid for 1 year. It is
Yes, my
expired.
lord. My lord, the advertisement is 12-12, my lord. My DPC recommendation is 18-2 of 22, my lord. So it is valid till, my lord, 17-2 of 23. The validity is of 1 year, and but vacancy here is up to December, my lord. So that post fell vacant within the year. So therefore,
Mr. Goswami, this is a straightforward matter.
my lord.
There is a panel
Yes, ma'am.
in which 4 persons in the top were appointed.
Yes, ma'am.
5 were in the another 4 were in the select list. Your client was in the top of the select list. You subsequently came to know that your client was number 1 in the wait list.
Yes, ma'am.
But the select list was valid for 1 year, which is expired. Today, that select list cannot be operated to appoint your client as assistant registered. The question doesn't arise. Now you want the current process to be stalled.
Yes,
because if that is not stalled, then your client will not get the relief on the basis of 18 to 2000. That cannot be granted. We
Exactly,
can dispose of that matter today itself. On the contrary, you are creating problems for your client. Maybe he will be selected.
Your lordship will kindly come to the, my lord, your lordship on annex. I would like to place, my lord.
Maybe your client might be selected as serial number 1 in the.
I don't know, my lord. This time.
Then without knowing it, why are you doing it?
No, my lord, but my right is from flowing from the that recommended list, my lord. And that is the law, my lord. They have to follow that.
Recommended list was valid for 1 year.
Yes, my lord. And this post fell vacant in December only.
Show me a judgment which has connected vacancy, arising of vacancy with the validity of list. One judgment you show me, Mr.
My lord, your lordship will I'll just place the law first, my lord. The rule that they are following. That is page 10, my lord.
Mr. Goswami, do you have any judgment which says the list will be valid with effect from the date on which the vacancy arose? Any judgment of any court?
No, this list is, my lord, valid from the date of that DPC, my lord. That is 18 to 22.
For 1 year.
For 1 year, my lord.
When did it expire?
On 17 to 23.
We are now in June 23.
maybe, my lord, the post fell vacant, that additional post, my lord, that fell vacant, my lord. So you did, I'll just read out, my lord, this, the rule, my lord. At page 10. Very short, my lord. Page 10, I have quoted, my lord. This one, clause 4.4.9 of the concerned rules, my lord, of the Department of Personnel and Training.
29.
D, my lord. Has your lordship found it?
Yes.
The officers who have already been empaneled or placed in the extended panel, but could not be promoted due to these vacancies not actually becoming available, need not be reassessed by the supplementary DPC as assessment metrics remain the same. They may be appointed against the additional vacancies of the same vacancy year as per recommendations of the earlier DPC. That is the rule. And the vacancy here is at 22 only. So
But
therefore, my
this
lord,
panel was prepared not for 22 vacancies. It was prepared for 21 vacancies. Vacancies will have to arise, then only there will be.
the second subsequent additional vacancy arose within the year 22, my lord. During which time my recommendation was valid. My valid even thereafter, but for that year too, I was valid.
Why did you come now? Why did you not come during the?
Only
validity?
now I have come to learn. You also will kindly come to page 53 once. This knowledge was not there. They did not update, my lord, upload all these things in their website.
No, knowledge was not there about what? That there was a vacancy.
No, my lord, that I was selected or that I was at empaneled at the top, my lord.
Anyway, Mr. Goswami, you argue, but a select list which has expired, it cannot be revived. That is the judgment of this court. So I am not going to change that view.
But your lordship will just come to page 53 once. This is a reply
If that
there.
was your argument,
My lord.
your client should have come earlier, saying that.
No, my knowledge was not there, my lord. Because
Correct, but then select list which has expired will not revive because you got knowledge later on. Expired select list is expired. Panel is expired. How can it be revived now? A panel which expired on 17th of February 2023. It has expired. Whether you had knowledge or you didn't have knowledge, the life of that panel was for 1 year.
But
that is gone. Will it now get extended life because your client came to know about?
But this is something, my lord, I am suffering because of their, my lord, respondents. They should have intimated me. Now they are saying that, how have you come to know, my lord? On the contrary, look, there, my lord, that is at page 53, my lord. They say on 9/6/23, my lord, on 9/6/23, even after my knowledge, my lord, if my knowledge was there, my lord, I wouldn't have come for the subsequent interview, my lord. I wouldn't have, my lord. I would have pressed it then and there itself. The rule is very clear, my lord. The knowledge was not there.
My lord, if I may, my lord. My lord, for a moment, we'll look into the advertisement, my lord. And it is absolutely clear in the advertisement under clause 3 that this list, whatever is there, is only will restricted to the advertisement which was been published. My lord, will see the advertisement for a moment. That has not been part of the petition, surprisingly. May I read, my lord? General information. The panel of selection waiting list drawn up by the Department Promotion Committee as per the Government of India norm would be valid for 1 year. If the post falls vacant within the 1 year, the DPC meeting, the same will be filled up using the waiting list category. This will not apply to the fresh selection of post made after the advertisement, my lord. So it is this advertisement, my lord, was the first advertisement. My learned senior is asking for an appointment in the second advertisement, my lord. Now, when the second advertisement come, my lord, I asked myself, what stopped petitioner from inquiring from the authority? What about the result of the first advertisement? He could have asked, he would have known around that time. This makes it absolutely clear, my lord. Whatever vacancies, whatever the panel list will be restricted to the previous advertisement. It will not flow to the subsequent advertisement. It was there mentioned in the advertisement itself. He abided by it, he applied for this.
You file your preliminary affidavit.
My lord.
When will you file it?
My lord will give us a week's time, my lord, if possible, to this on the report. Or
week's time.
Week's time,
We'll have it next Wednesday for motion.
My lord.
You file your affidavit by Tuesday.
Preliminary affidavit, my lord.
Yes, preliminary.
My lord.
Let them file the preliminary.
In the meantime, they will not act on their.
No, then I'll go into the
No, no,
detailed
that-
interim order and pass an order if you want. I'm waiting for the affidavit. Mr. Goswami, you have not made out any case for interim order.
No, my lord,
Then I'll pass a detailed order.
my lord,
But
my,
I wanted him to file his affidavit so that if some relief can be couched out for your client.
well, it will be very short. Issue is very short, my lord. They can file on
If you
Friday
thought
also.
you don't have any
My-
case,
Friday also.
why don't
My
we
lord, I-
finish it today itself?
Or on
On
Monday.
based on materials available,
My lord.
there is no case. There is no case.
Let
He has
them
been
let them
sleeping.
file the affidavit, my lord. I
Let him
don't have
file.
any.
That's why I'm saying, let him file the affidavit.
By Monday,
Then we'll
Tuesday
see.
we'll file it, my
Yeah.
lord. By
By Monday, you file affidavit.
My lord, can it be on Tuesday, my lord, because my senior is actually unwell, that is why he left.
Achha.
Get me back, so on a
So
Tuesday.
we'll have it on Wednesday.
Yes, my lord.
Mr. Goswami, prima facie, the petitioner's case is not convincing at all. Both from the technical rules point of view and from his explanation point of view.
Well, let them file the affidavit, my lord.
So therefore, I'm saying if you are pressing for an interim order, I have to give a reasoned
No,
order.
my lord, they are filing the affidavit on Tuesday, my lord.
That's
My
why-
matter is coming up on Friday. That till that
Let us wait
limited,
till-
very limited, my lord. Till then, they,
My lord,
that date, my
I don't know.
because issue is small, your also is already hard, but
Not.
because
You
my lord,
are damaging your client's
My lord.
prospect, Mr. Goswami. I'm sorry to say this. For all you know, he might be the one getting the first position of promotion. Then the only
my lord,
question.
my learned friend is saying that, my lord, I should have asked, my lord. Am I the authority?
All right, you don't do anything. Supposing your client is in number 1 in the panel.
And I do not know, man.
Oh, why don't you wait for that?
No, I do not know, my lord. How do I know, my lord? They have to ask- ask for it, my lord.
Counsel for the petitioner. also
ABD.
have Mr. ABD, learned counsel appearing for the IITG who prays for time till 20th of June 2023 to file a preliminary affidavit placing on record the basic facts which would tend to belie the case of the writ petitioner. Mr. Goswami, on the other hand, submits that the Board of Governors or Board of Directors?
Board of Governors.
Board of Governors of the IITG is likely to take a decision on the question of
On tomorrow or day after.
decision in a day or two when the question of filling up fresh vacancies in the rank of assistant registrar and therefore an interim order be passed by this court. After hearing the submissions made by learned counsel for both sides, this writ petition is directed to be posted again on 21st of June 2023 for motion as a fixed item. Affidavit on behalf of the IITG be positively filed on or before 20th of 20th of June 2023 bracket 2 p.m. by serving advance copy upon the petitioner's counsel. Full stop. Yes, what is this?
My lord, petitioner is, my lord, pursuing for compassionate appointment. My lord, my lord, he was selected along with others. Lord, you will find the select list at page 14. 11% at page 15.
Yes.
One,
is your
two,
step,
three.
Mr.?
1, 2, 3, 4 her person has appointed, even 5 have appointed. My lord, living beside my lord, me. And she was appointed in the year 2013.
Yes, Mr. Goswami, what is?
My lord, as per the instruction received, my lord, state level committee has rejected his case.
Why?
I'm saying this. my lord.
Where is the resolution? Page number?
My lord, in my writ petition also annexed, my lord, at page 33. 33, 11% at page 34, my lord, saying that 16 years have elapsed. But whereas, my lord, the respondent 5 has been appointed later on, my lord, in 2013. 5 has been appointed 2013. I have made a statement, my lord, in paragraph 5. If that her case is considered after 12, 13 years later, why my case cannot be, my lord?
Father died on 5/3/2021.
My lord.
We'll post it for
Yes, my lord.
hearing in usual force.
2001.
Another 20 years.
My lord.
22 years back, father died, you are seeking compassionate appointment now. How it can be done?
My lord.
Which principle will
My
come to
lord,
you?
person below than me, my lord, has been appointed. my lord. That is my case, my now. Otherwise,
Person below you means below in
my
what?
lord, in the select list, my lord, the original select list, my part.
Maybe below, this is not a gradation list.
No.
Below or above is not the point. Point is, has anybody whose case was delayed by 16 years has been
My lord.
appointed?
My lord, my lord, she has been appointed 2013. After 12 years, 11, 12 years
Next
later.
person was rejected. Viva Match. Then Nazrul Islam has been rejected, lost its compassionate ground, 7 years delay. So similar, they've given same treatment to others.
They are not before your lordship.
No, that can't be done. Heard Mr. A.S. Sikdar, learned counsel appearing for the petitioner. Also heard Mr. B. Goswami, learned additional AG Assam. Who is respondent number 5?
Respond number 5, my lord. Yes. For people.
Learned additional AG Assam appearing for the respondent numbers 1, 2, 3, and 4. And Mr. Ayat Alakdar, learned counsel appearing for respondent number 5. First up, aggrieved by the meeting of the state level committee held on 2/6/2017, rejecting the petitioner's application for appointment on compassionate ground by holding that the application has lost its compassionate element due to delay of more than 16 years after the death of the employee. The instant writ petition has been filed. It appears that the father of the petitioner died in harness on 5/3/2021 while serving as a khalasi under the executive engineer Kachar of WR division. First up, after his death, the petitioner had submitted an application seeking compassionate appointment, which was forwarded by the DLC Karimganj wide resolution dated 6/8/2007. First up, by the impugned resolution, the SLC had rejected his prayer. First up, Mr. Sikdar submits that the persons whose applications were received after the petitioner's application have been considered and have been appointed, but his case has been rejected. First up, the learned counsel for the petitioner, however, could not convince this court that candidates who had approached with similar delay and were similarly situated as the petitioner had also been had been accepted by the SLC. First up, the petitioner has made a prayer to set aside the appointment of respondent number 5. However, no such case has been made out on the facts brought on record. Full stop. It has been reiterated time and again that the scheme of compassionate appointment has been framed by the government of Assam so as to give immediate relief to the family of the deceased employee, which had lost the sole bread earner. First up, such a scheme does not put in place a mechanism to guarantee employment as a matter of right. First up, if a person could survive more than 22 years without a government job, there is no reason for this court to presume that the element of compassion is still alive in case of the petitioner. Full stop. This court is therefore of the opinion that the SLC has rightly rejected his case. Consequently, this writ petition is held to be devoid of any merit and is accordingly dismissed.
Well, the issue relates to the non-release of the death benefits of the petitioner's father, who died while in office. Where the council, government council may be asked to take instructions, my lord. The impression that I was given, the instructions that have been given, my lord, is that there are moves to clear the dues. So, my lord, let them take instructions in the meantime. My lord,
Worship, some time may be granted to see instructions.
I don't mind. Let them take some time.
Had Mr. T. M. Srinivasan, learned counsel appearing for the writ petitioner. Also had Mr. D. Bora, learned government advocate Assam, appearing for the official respondents who pays for how much?
After revocation.
4 weeks time to seek instruction facilitating disposal of the writ petition. Since the prayer is not opposed, same stands allowed. Let this matter be listed after the summer vacation so as to enable the learned government advocate Assam to obtain instruction.
Right.
May it please your lordship.
Yes.
My lord, today morning, as per order dated 17/1/2023, my lord, I have filed my affidavit, my lord.
I have also received a copy, my lord.
All right, had Mr. B. Raman, learned counsel for the, you want to file rejoinder? Rejoinder or not?
If necessary, after the verification, my lord, I will file.
If necessary, after
Perusal of
the judgment is delivered.
No, no, my lord.
Who will tell if
My lord,
necessary? You are the one.
My lord.
You don't want to file rejoinder, then we'll close it here.
If necessary, I will file, my lord. They have in that every they have made some financial, my lord, statements. So I will
B.
verify.
Raman, learned counsel for the petitioner, also heard Ms. R. S. Deori, learned counsel representing the respondents, all respondents.
No, my lord, for respondent number 2, 3, and 4.
Respondent numbers 2, 3, and 4 who submits that counter affidavit on behalf of our client has been filed only this morning. But the same-
Additional affidavit, my lord. Counter-
Additional affidavit on behalf of our client has been filed only this morning, but the same is not on record. Mr. D. Bora, learned government advocate Assam is present on behalf of.
1 and 5.
1 and 5. In view of the above, let this matter be listed again after the summer vacation, along with the additional affidavit. The petitioner may file rejoinder in the meantime if so advised.
May I please, your lordship? Lordship, on last order dated 19/5/2023, lordship.
Yes, lordship, lordship directed me to obtain instructions, lordship. I have received the instructions and I'll file an affidavit, lordship, additional affidavit. In that case.
What is your instruction?
Instructions is there. Their overage was condoned. They were allowed to appear in the interview, written test, but they were not qualified, lordship.
Then what
So I
remains
want to
is-
file an affidavit in this.
Close
regard.
it today itself, if that is, you have written instruction. What remains in this case? Your age was condoned,
My lord.
then you did not succeed on merit. What else is there in this case?
My lord, as per last order. Kindly may perish at page, last page 86, your lordship. Basing on that order, your lordship was pleased to pass the order.
All right, I heard Mr.
Abi Ahmed.
M.U. Ahmed, learned counsel for the petitioner. Also heard Ms. D. Bora, learned standing counsel, Health and Family Welfare Department, Assam, who submits that she has received instructions in the matter and therefore we permitted 2 weeks time to file affidavit. Prayer allowed, let this writ petition be listed again in the 3rd week of July 2023. Affidavit on behalf of the department be brought on record in the meantime.
Lord.
Lordship, the petitioner before your lordship is a peon, lordship. Grade 4 employee in Guwahati Municipal Corporation. He was absent from duty from 15/9/2018 to 6/1/2019, lordship. On 7/1/2019, he appeared before the authorities and filed an application for allowing to join him as well as for leave of those absence period. That is, lordship will find that page 32, Lordship.
Yes, have you got the judgment? Judgment of
Lordship,
this
I
court?
have tried to find out factually, Lordship, this is different cases.
All right, then we'll hold it, we'll have it after vacation.
Lord-
It'll take
Lord-
some time. Mr. U. Datta, learned counsel for the writ petitioner is present. Also heard Mr. S. Bora, learned SC, GMC appearing for the GMC authorities. Miss A. Talukdar has appeared for the state of Assam. So respond number 1. On the prayer of learned counsel for both the sides, this matter is directed to be posted for admission hearing again in the first week of August 2023.
Obliged.
Lordship, in this matter, notice inviting job applications is under challenge. I'm appearing for the council. Would like to withdraw that notice, Your Lordship.
Mr. S. Bothakul, learned counsel for the writ petitioner. Also heard Mr. K.P. Pathak, learned counsel appearing for the TIA Autonomous Council for 3 weeks time.
No, we want to withdraw the impugned notice, Your Lordship.
Who submits that the Autonomous Council has decided to withdraw the impugned notice, and therefore leave be granted to that end. Leave of this court be granted for the same. If the impugned notification dated, what is the date?
It is undated.
It is undated, Your Lordship.
Impugned notification
Page 53 annex study. Your Lordship.
at page 53 annexure
E.
E is withdrawn, then nothing will survive for adjudication in the writ petition. Mr. Bothakur has also agreed to the said proposition. In view of the above, by granting leave to the respondent number,
All the respond number 1, Your Lordship.
respondent number 1, that is the TIA Autonomous Council, Morigaon, to withdraw the impugned notification, this writ petition stands closed. The exercise be carried out and completed within 10 days from today.
Obliged.
Will be given liberty, Your
The
Lordship.
exercise of withdrawal of the notification be carried out and completed within 10 days from today. What liberty you want?
No, if we feel agreed.
Who has stopped you? Has anybody stopped
Since-
you? Then needless prayers need not be made. Yes.
Obliged.
Mr. Bhuya, there is darkness in front of me. Do you see light in front of you?
No, my lord.
Then do you have a good case?
My lord, that the mother family function matter, my lord. Both the wife is agreeing, my lord, that some amount should be paid to me, my lord. My lord, in that line, my lord, can be disposed of me.
I am for the second wife, my lord. And I have made a statement that I am receiving 50% of the pension. The first wife is also receiving the 50% of the pension. That was an agreement reached between us during the court proceedings of an earlier
Petitioner
litigation.
is the mother.
Is the mother.
Mother.
I have also filed a petition on different ground although that there was a move by the authorities to disrupt this arrangement which follows from a judicial order. And therefore the interim protection is there. Now we have filed an affidavit as it had fallen that, okay, there can be 3 shares, no difficulty. But considering that I have got 2 sons whose education has suffered and I've given detail. So the share may not be equal. That will leave it to your lordship.
No, if you agree, then we can.
We agree, we agree to 3 shares, but we say that is a mother, she has other siblings as well. We are left at large because we do not.
So you say how much, which part, what is the percentage?
So far as presently, I'm getting 17,000, 50%, he would get 17,000, 34,000 or would be total.
10% from both the shares will be taken out and given to mother.
Very good. Very good.
That's. You are agreeable?
Gotcha.
I'll check. Take down. I heard Mr. Air, we are learned counsel appearing for the writ petitioner in item
Lord, in item number 35.
35. Also heard Mr. Air Banik, learned counsel for the writ petitioner in item number 36, who is also the respondent number
My lord,
6.
6 in writ petition 35. Mr. M. Islam Learned Council has appeared for respond number
5 million. Murshida Begum.
5 in item 35. Mr. S.S. Roy, Learned Government Advocate Assam, is present on behalf of the respond numbers 1, 2,
3 and 4.
3 and 4, whereas 1,
10.
2, 3 and 4.
He will for 10 in my case, 36.
Acha. Respond number 5 in item 35 and respond number 10 in item 36. His name. Mr. So-and-so for the official respondents, full stop. The both these writ petitions are interrelated and therefore are being taken up for disposal by this common order, full stop. The son of the petitioner in item 35, namely late Tayyab Ali, was an employee of the was serving in the Assam police. Full stop. While on duty, he had suffered a road accident. Full stop. Suffered a road accident and died on 15/9/2019. Full stop. The respondent numbers 5 and 6 are the two living spouse of late Tayyab Ali. Full stop. Since Tayyab Ali was entitled to receive pension from the department, both the spouses, bracket wives, had shared the family pension at the rate of 50:50. Full stop. Consequently, the respondent, both of them are receiving an amount of rupees 17,000.
Yes, 7,000.
17,000 each, being 50% of the family pension. Full stop. While the said arrangement was going on, the writ petitioner in item 35, that is the mother of late Tayyab Ali, had approached this court by filing the instant writ petition, inter alia contending that since she was also dependent on her son Tayyab Ali, hence a part of the family pension be shared with her as well, since she is unable to support public sustain herself. Full stop. During the course of proceeding of these writ petitions, the learned counsel for both the spouses as well as the mother have obtained instructions and submits before this court that they are willing to go for an amicable settlement of the dispute in this matter. Full stop. It has been agreed that 10% of the amount received by respondent numbers 5 and 6 in item 35 can be shared with the petitioner, that is the mother of the deceased employee. In other words, a sum of rupees 1,700 per month, 1,700 into 2 per month can be paid to the mother of the deceased employee, namely
Tamiyan Bibi Milo.
Musammat Tamiyan Bibi, from the family pension receivable by the two wives of the deceased employee. Full stop. Mr. S.S. Roy, Learned Government Advocate, submits that if a direction is issued to that effect by this court, the department will do the needful. Full stop. Since all the parties have agreed to the above arrangement, and considering the facts and circumstances of the case in its entirety, this writ petition is, these two writ petitions are being disposed of by providing as follows. Number one, the mother of the deceased employee, namely Musammat Tamiyan Bibi, will be entitled to receive 10% of the share of family pension receivable by each of the two widows, wives, no widows of one, instead of wives, make it widows, of deceased Tayyab Ali, subject to revision of the pension from time to time. Full stop. The respondent numbers 5 and 6 in item 35 to submit a joint application before the
There was already, there's already an application for sharing 50-50.
No,
The
no.
order of the court would now cover that. Because the,
joint application before the respondent number 2, respondent number 3. By enclosing a certified copy of this order. So with a request to do the needful full stop.
The AG is not a person.
The petitioner in item 35 assures this court that the
That is-
petitioner in item 35 will furnish necessary particulars of her bank account,
Mal.
etc.
Mal.
for receiving the amount of 10% from the share of each of the 2 widows of Tayyab Ali. Full stop. With the above arrangement, the dispute inter se between the parties regarding share in family pension of Tayyab Ali shall be resolved permanently. Would then resolve permanently. Yes.
consequently, my lord, the impugned order in 36 needs to be set aside, which grants everything to her. At page 38.
In view of the above arrangement, the impugned order dated
5/9/22.
5/9/2022. In item 36. Whereby the entire amount of pension has been granted in
To the
favor
first
of
wife. Murshida
the
Begum.
first wife, that is
Murshida Begum.
Srimati
Begum.
Murshida Begum stands interfered with. Both the read petitions stand disputed.
My lord, 10, total of 20%, maybe. 10%.
That you find
10% is that.
10% each.
Obliged.
Huh?
Which set aside, that amount is divided into. Actually, now this order follows whereby.
Set aside by providing that the family pension receivable on account of Muhammad Tayyab Ali shall henceforth be divided 50-50 between the first wife and the second wife.
Obliged.
There is a somebody has mentioned a matter, some outstation council. 39, we take up that matter in next 10 minutes. What is this?
So this was a case where 25% reservation ought to have been there for promotion.
After vacation. After vacation. No time.
May I pray for a date, Miller?
Yes.
May I pray for a date?
You decide choose the date on the request of Mr. Bali and counsel for the petitioner. This matter is directed to be listed again on
Any day after reopening.
2nd of August 2022. Mr. D. Bora, and the government advocate.
Here, Lordship, I request some time, Lordship. I have not received the instruction.
Also for the petitioner on the request of Mr. S.S. and the government advocate also. B.S. Tam.
My lord, in pursuance of order dated 28/4/2023, no initiative has been taken by the respondent, my lord. Already 5,730 post, my lord, 5,421 is result declared, my lord.
There is a stay order, Lordship. Already said.
This matter stands adjourned for 3 weeks, so as to enable him to obtain instruction.
Interim will continue.
Interim order passed from you to continue.
My lord, as per the order, it was from 29/5/2023.
Are you seeking disposal?
My lord, with the bank is retiring on 30th of this month. So if your lordship pleases, then matter may be taken up on Tuesday next.
I have the selection record, otherwise I directed by your lordships. Lordship may produce it or. As it because no affidavit has been filed because notice has not been issued.
Notice not been issued?
No, only the selection records were directed to by lordships to be produced. I have brought the selection record. Lordship can-
Had Mr. S. Learned counsel for the petitioner also had Mr. A. Ganwadi, learned counsel appearing for the respondent bank, who submits that he has received the records. In view of the above, let this matter be listed for motion again on Thursday. Thursday for motion.
Mal,
No, Thursday, Friday for motion, sorry.
Friday,
Coming Friday, day after tomorrow,
day after Tuesday, my lord.
Tuesday.
Tuesday, day after tomorrow, I will not be in
All right,
station.
Tuesday for motion.
My lord, in this case, service upon newly implemented response number 89 has complete. Maybe my learned friend is appearing. Matter may be fixed for admission, my lord.
It is submitted at the bar that this matter is ready as regards service and therefore can be taken up for admission. Register to verify and leave this case for admission after summer vacation.
Deep level.
Any date, my lord? Any date?
Summer vacation. It's a part-head matter. Item 44. None appears for the petitioner on call. This matter stands adjourned for 4 weeks. Yes. My plea, my lord, order dated
In this case,
27.
Lordship, already family pension has been approved, my lord. Only my lord, 3 copies of the single photograph of the petitioner is required, my lord, and it is attested by the chief executive officer. Lordship. That's all.
My lord, Lord Mr. M. Islam, learned counsel for the petitioner. Also heard Ms. D. D. Burman, learned counsel appearing for the respondent numbers.
Respondent number, Lordship. 8.
Sorry,
Newly, director pension, Lordship.
respondent number 8, who submits that in this case, the family pension of the petitioner has already been approved. And as soon as 3 copies of photograph
3 photographs is required, blood, newly attested by the chief executive officer.
duly attested by the chief executive officer of
Kasar Jilla Parishad, Lordship.
Kasar Jilla Parishad is produced before the respondent number 8,
Yes.
the pension will be released. First of, similar the stand of other respondents appear in this case. In view of the above, this contempt case stands closed by providing.
No, my
that-
lord.
Yeah,
There is a my lord dispute still remains, my lord, because they have considered only 17 years. Whereas the my lord kindly see para 12, my
in
lord,
view of
page
the
20.
above, this matter stands adjourned for 4 weeks so as to enable the petitioner's counsel to do the needful for submission of the attested photographs. Yes,
Outline. Item 46.
first to get the pension, then we'll see. Yes.
The order was to pay the pension within 5 months. That has passed. So, my lord, your lordship,
Notice has not gone.
no, my lord.
Had Mr. B.D. Cole and senior counsel assisted by Ms. P. Gupta. P. Gupta, is it? Like counsel for the petitioner. Alleging willful disobedience of the order dated so and so passed by this court in WPC number so and so. This contempt case has been filed. I peruse the statements made in the contempt petition. NOM 8 weeks. Steps by registered person.
Deep level.
Lordship, in this case,
Yes.
Lordship, notice was issued and there was an interim order in my favor. They filed their affidavit. And on the last occasion, when we paid for time to file affidavit and reply, inadvertently, there was no prayer on our behalf for extension of the interim order, madam. So for abundant portion, we have preferred this IA, your lordship, 1668 of 2023 for extension of interim order, madam.
Had Ms. B. Bhuya Lanet, senior counsel appearing for the applicant, also had Ms. A. Talukdar Lanet, government advocate Assam appearing for the opposite parties. His IA has been filed with a prayer to extend the interim order passed by this court on 5/9/2022 in WPC number 5568/2022. Ms. Bhuya submits that on the last occasion, when the writ petition was listed before this court, the matter was adjourned, but due to inadvertence, the prayer to extend the interim order was not made. First up, contending that unless the prayer for interim order is extended, the writ petition will become infructuous. Ms. Talukdar Lanet, government advocate Assam, submits that she would have no objection if the prayer is allowed. In view of the above, this IA is hereby disposed of by providing that the interim order dated
5/9/2022.
5/9/2022, passed in WPC number 5568 of 2022, shall stand extended until further orders.
Lordship, date may be fixed, Lordship.
Date may be fixed in what?
We'll file an affidavit on the last occasion took time.
Registry may leave the IA after 3 weeks. So as to enable the parties to exchange pleadings. IA stands closed.
Compliance, Lordship.
How many more cases are there? Don't call that upgraded hearing.
In this case, the reply has been filed by the government has been filed in reply.
3 weeks time may be given to us to file our affidavit.
Mr. B. Pukas, the learned counsel is present on behalf of the petitioner. Mr. PD Hazarika, is it P. Hazarika?
P. Handick, my lord.
P. Handick, learned. standing
On
counsel.
behalf of Additional Advocate General K. Ko, my lord. This is not a PNRD matter, my lord.
Then what is this?
This is a matter pertaining to disciplinary proceedings that we initiated against the
Then you will
petitioner.
record the name of the counsel because this confusions.
He is in the Transformation and Development Department, my lord.
Learned standing counsel appearing for the.
Planning department, my lord.
Huh?
Transformation and planning department.
Department of Transformation and Development. That is the respondent's hearing. I have prayed for 4 weeks time to file affidavit. A prayer allowed, let this matter be listed after the counter affidavit is filed by the respondent. Interim order passed earlier to continue.
Compliance.
For hearing updated matter, I just have to answer.
My lord, I am appearing for the applicant. I am extremely grateful that your lordship has upgraded so that I can try to complete the argument by today. I shall be as brief as possible. I have prepared a detailed notes of written arguments supported by rules, regulation, and other relevant judgment. As your lordship knows that of late, Honorable Supreme Court and inclusive of all high courts, including your lordship, prefer written notes of argument so that unnecessarily we should not argue and waste your lordship valuable time. So I can place this written notes of argument if it's convenient to your lordship, and on that basis I can start the argument. And 2-3 more is necessary to be produced.
That is the written argument.
Yes.
You are
I'm
expecting a
submitting
judgment in
written notes of
2024.
argument. Yes.
I'm not going to go through this written argument. This is how many pages?
Along with
give
the
it,
rule-
we'll keep it.
along with the rules and regulation, after
More
my
than 2-3
argument, I can
pages.
submit if your lordship prefer.
This you can keep it or give it to us. Nobody has the time to go through this. This must be 100 page.
More than, because all the rulings are there. I have to place those ruling, my lord.
If you have luggage weight problem, then you leave it behind, or else you can take it back. We are not going to go through this fact and written argument. It's better you make your submissions. But,
that definitely I will be.
Summary of arguments in a capsulated form, yes, that we
Yes,
appreciate.
okay,
That
grateful.
helps.
Okay.
But this is bigger than the writ petition.
Because of the fact, my lord, rules, regulation, and civil judgment has been enclosed. That's the way it becomes a voluminous. Otherwise, it could not be. My written notes of argument is very short.
Your written argument is daunting enough, intimidating enough. You say you will take half an hour and you have a written argument of 100+ page.
Anyway, let me
Yes.
see beginning.
May I know your name, please?
M.R. Sarvadikari.
M.R.
Sarvadikari. Manav Ranjan Sarvadikari.
Okay, okay. You are from Calcutta?
Yes, I am practicing in Calcutta High Court. But I have been compelled to come because of this application. Of course, I am not taking any sympathy from your lordship. It is practically lapse labor because the applicant is almost penniless. So only the bear my traveling cost and staying. Anyway, that's a different thing, my lord. My lord, this writ petition is necessitated on the basis of the two order. One is the order dated.
Mr. Adhikari, will you please take your seat for 2 minutes? I'll just go through the. So you are challenging the major penalty of removal from.
No, my lord. That is a closed chapter. That is a closed chapter. After the major penalty, it has been filed in a writ petition. The writ petition has been dismissed. Then the applicant has preferred an appeal. In course of the hearing of the appeal, it has transpired that the applicant has retired, superannuated, because charge sheet has been issued just 6 months before. So on legal advice, it was decided that the writ petitioner will only claim the terminal benefit. So on that basis, Honorable Appellate Court presided over by Honorable Chief Justice Mr. Ajay Lamba and Mr. Justice Soumitra Sakia, order dated 21/1/20. So may I place this order?
Yes, please. Yes, please.
It is a short order, my lord.
Yes.
Then, my lord, my supplementary affidavit for release of the terminal benefit has been filed and bank has filed a objection to that. And thereafter, matter came up before same appellate branch, but this time it has been presided over by Honorable Chief Justice Mr. Sudhanshu Dhulia as well as Mr. Manas Ranjan Kar. May I place that order? Order dated 21/4/2021.
So there is a writ appeal pending.
No, writ is not pending. In the writ, the release of the terminal benefit.
There is a writ appeal pending.
No, my lord, the writ appeal was disposed of with the direction that the learned single judge had not gone into the issue of payment of the retirement benefits at the time of adjudicating the writ petition. The writ petition was dismissed on the, as far as the challenge to the disciplinary proceeding was concerned. But as far as the retirement benefits was concerned, gratuity, pension, etc., there was no observation, no decision, and in fact, there is no discussion also of the learned single judge.
So the
limited-
limited petition means this writ petition, WPC 4500.
Yes, 4500 of 2014.
Yes.
So this writ petition has now been revived.
It has been restored on the limited question of the retirement benefits.
Whether retirement benefits
Release
should be
entire-
released or not.
That is
That is the whole question.
Your lordships.
So what are the retirement benefits you are seeking?
That is, my lord, gratuity, pension, and leave encashment. It is very relevant to point out that higher order dated Honorable Justice B.K. Sharma has released the 50% of the gratuity amount. Judgment of this.
Then now you said there is an order of the Supreme Court to decide this matter expeditiously. Is there any order of Supreme Court?
No, Supreme Court, because there was no scope of going to the Supreme Court. It is only on the basis of the order of the appellate court of here.
The division bench directed.
Division bench direction is there. Just say, I have mentioned, I have given the order of Honorable
No,
Chief
in
Justice.
the morning you refer to Supreme Court. That is not correct.
No. So I refer Supreme Court judgment regarding release of the terminal benefit. I have not, there was no scope of going to Supreme Court yet, my lord, because it is, the discussion is on the basis of the Honorable Chief Justice, last Chief Justice order. Chief Justice
So
of
what
this
is the
court.
law in case of removal from service? This gratuity, pension and leave encashment are to be paid.
Yes, are to be paid. That I respectfully submit, I may be permitted to submit that rules, regulation in the Punjab National Bank.
Are you denying it?
In the meantime, let me submit. In the meantime, may I submit the one decision of this court, Honorable Mr. Justice B.K. Sharma. I place this judgment wherein, when during the pendency of the appeal, Justice Sharma has directed to release the 50% of the gratuity. Paragraph 28, last paragraph, making detailed discussion in this judgment.
Yes.
Paragraph number 15 to rest are very relevant in this respect. So on the basis of this judgment and other rules and regulations, my respectful first submission is that 50% of the gratuity amount may be released. And if I ask this question to myself, that why? During the pendency of the appeal, Honorable Justice BK Sharma has been pleased to release the 50%. And now my respectful submission is release of the further 50%. Why? So in this respect, may I place the bank's own circular. May I place this? Of course, it has been already bound, so I am place this payment of debt. I take to be the again. Did you note of argument? My lord's particular reference is page 8 to 11, clause 3, wherein it has been circular has been specifically mentioned. In case of officers, there is no provision for forfeiture of gratuity under officer service regulation. Specifically mentioned, this is bank circular. And on the basis of this circular, Honorable Justice BK Sharma possibly released the 50% of the gratuity. Bank's own circular instruction say that forfeiture of there is no provision for forfeiture, but there is a provision for forfeiture under Gratuity Act. But as your lordship knows that when there is a conflict between Gratuity Act and the bank service own regulation regarding gratuity, which is also statutory for, the latter one shall prevail for getting better benefit. And if your lordship again kindly go to Justice BK Sharma's judgment, wherein it has been specifically mentioned this point and mentioned that where under which provision gratuity can be forfeited. If an employee or officer dismissed from the service for riotous behavior or moral turpitude or criminal act, then only gratuity can be forfeited. But otherwise, gratuity cannot be forfeited, and if particularly there is no loss. In this case, it has been specifically hold that there is apart from charge sheet, it is a lengthy one. I again refer to Justice BK Sharma's judgment, which has not been appealed and 50% delete, wherein Justice Sharma specifically hold that there is not an iota of evidence anywhere that bank has sustained any loss. Why? The charge is against the applicant is that State of Assam, like all other states, has granted certain subsidy for sanctioning loan to the peasant and small trader. When the loan has been sanctioned, suppose 10,000 as the loan, so 8,000 has been sanctioned and 2,000 subsidy has been paid. This loan has not been sanctioned by the applicant. Has not at all been sanctioned because applicant has submitted that there is a very chance of loan become NPA. So he did not dare to submit. So there was a pressure on the bank manager, applicant from the government of Assam, particularly BDO, that you pay the subsidy amount to the respective borrower without sanctioning loan. So in this respect, may I submit the letter of this BDO. It was specifically the addiction, but there is technical lapse, but that is a closed chapter because Honorable Reed Court has dismissed the punishment of removal from service, holding that it is correct. There is procedural lapse. There is no doubt about that. That loan should be sanctioned, but under these circumstances, the rule is that subsidy should be returned, but it should be returned within 6 months. But 6 months has been long over because loan has been sanctioned about the subsidy has been given 5 years back. So long the amount has been kept in the bank's coffer. Somehow or other, this manager, his position is like he was caught between the devil and the deep blue sea. There was a pressure from the government of Assam, and there is non-compliance of the technical rules that why you will return the subsidy to the borrower and to prospective borrower. So this technical lapse is there is no, but there is not a single paisa loss. Bank's fund is not at all involved. And so Gratuity Act never stipulate or bank's own gratuity rules that if there is any loss, it should be, gratuity should be forfeited. But for argument's sake, even if there is a loss, the loss amount can be deducted, the rest amount can be returned. For argument's sake, if it is whole, that yes, no, there were certain losses. That can be, but there is no loss.
50% of gratuity
Has been already been paid by.
What is the amount? What was the amount?
Total amount was 5 lakhs, total gratuity amount was 10 lakhs.
But now it has, act has been amended to make it 20 lakhs.
20 lakhs. But when he has retired, at that time it was 10 lakhs. So I cannot claim because it was not given prospective effect. So to be very fair to your lordship, I cannot claim for 20 lakhs. It is 10 lakhs. 50% has been released, balance 50%. On this basis, there is no loss and at all. So this should be.
All right, this is insofar as gratuity is concerned. What about
now about the pension? May I place this pension regulation again, my lord? This pension regulation has been in that booklet. It has been specifically mentioned. If your lordship kindly the rules, regulations 42 to 48. Chapter 9. In that booklet, it has been mentioned.
what
regarding
is the page,
release
what
of
is
the
the
pension.
page number? Page number.
Page number, my lord, page number is not there. May I find out? Sorry, my lord, my opinion is not doing. I can help you. Extremely sorry, my lord. I told him, but
All right, all right.
extremely sorry. I apologize, my lord.
It's all right.
Somehow or rather, he did not mention the page number. Grateful, my lord.
Mr. Purkasto, what are you waiting for?
One fixed item, what you have fixed the matter.
Hmm?
Item number, I think, 47 onwards. Hearing matter.
So your wait will be quite long.
I know, yes. Because Lordship has fixed the matter on the last occasion, I could not appear, madam. That's why, my lord, I thought, my lord, if I don't appear today, Lordship may take an adverse.
Let us see, this will take some time.
My lord.
Your lordship kindly go through
This is
Rule
what, this is
42
part of
onward.
the banking rules.
Banking pension regulation, which is the statutory force. Passed by the parliament and adopted by the bank, all nationalized bank. There is no denial of that. My lord. Forty-three, my lord, onward relevant. 43, 44, 45, 46, 47, 48. As I have submitted that if there is any loss, it should be recovered. Page for rule 48 specifically mentioned. Recovery of pecuniary loss to the bank. Specifically mentioned, whatever I have submitted. And more particularly, the page 48 rule, sub-rule 3, it has been specifically mentioned where the competent authority orders recovery of pecuniary loss from the pension, the recovery shall not ordinarily be made at the rate exceeding 1/3 of the pension admissible on the date of retirement. Here, my lord, disciplinary authority has not passed any order for forfeiture of pension. So forfeiture of pension can be taken only by the competent authority. And which is the competent authority? That has been defined in the pension regulation itself, wherein it has been specifically mentioned, competent authority means the authority appointed by the board for the purpose of this regulation. Specifically, definition 2H, competent authority. Specifically mentioned. But there is no such decision by the competent authority. Simply, they have relied on this, that since he has been removed from the service of the bank and this has been upheld by the Honorable High Court, so he is not entitled for anything, which Honorable Justice B.K. Sharma did not agree. So on the basis of this regulation, my lord, my respectful submission is that he is entitled for pensionary benefit also. These are the rules and regulations. Now, my lord, if your lordship permit me, I can refer the judgment. Because of that, that has been become voluminous. So many judgments, my lord. But I can simply submit in my notes of argument that will do. Your lordship need not go through this judgment. Simply I can, if your lordship kindly see, page 5 onward. I have mentioned specifically the reference of the judgment as well as the what is the basis of the judgment. Paragraph 8, page 5 of my written notes of argument. But before that, paragraph 4 is also relevant. Paragraph 3 is also relevant. On the basis of the S.K. Cool's judgment, landmark judgment. Your lordship knows that wherein it has been mentioned that pension is a statutory right and it should be given. It is not depend on the bounty of the employer. And this judgment has been upheld by subsequent Honorable Supreme Court in Assistant General Manager Radheshan Sharma versus State Bank of India. And not only that, before that 1951, 4-bench judge, Devkinandan Prasad case, Supreme Court, hold that this is a pension is a property and it should be released. 1971, that Devkinandan Prasad judgment I have include in this judgment, in this that set at rest everything, because that judgment has been followed like Kesavananda Bharati's case, Goloknath's case, Manika Gandhi's case. It has not been set aside. 4-bench judges should prevail. So that 1971, no doubt it is a old decision, but it is prevailing. Devkinandan Prasad versus partner, state of partner. Paragraph 20 of my judgment, of my written notes of argument, I have mentioned this only one judgment. The antiquated question of pension being a bounty, a gratuitous payment of depending upon page 7, that they will my written notes of argument, my lord.
Yes.
The antiquated notion of pension being a bounty, a gratuitous payment depending upon the sweet will or grace of the employer, not claimable as a right, and therefore no right to pension can be enforced through court, has been swept under the carpet by the decision of the Constitution bench in Devananda Prasad versus State of Bihar, 1971, 2 SCC 3, page 330. I have enclosed the judgment, wherein the court authoritatively rules that pension is a right and the payment of it does not depend upon the discretion of the government, but is governed by the rules, and a government servant coming from those rules is entitled to claim pension. It was further held that the grant of pension does not depend upon anyone's discretion. It is only for the purpose of quantifying the amount having regard to service and other allied matters that it may be necessary for the authority to pass an order to the effect, but the right to receive pension follows from the officer not because of any such order, but by virtue of the rules. The view was reaffirmed in State of Punjab versus Iqbal Singh, 1976, 2 SCC. Thus, from 1971 onward, the Apex Court consistently held that pension has to be given to employees who attain qualified service, and it cannot be denied under any circumstances. So, thereafter, my lord, Rajasthan Pandey versus State, same view has been held by the Honorable Supreme Court, latest judgment. Assistant General Manager versus State of West Bengal, civil appeal number, civil appeal, that is also same view. I need not trouble your lordship. Your lordship definitely will go through. It is held by and before that, there is another decision of the Shashikala Devi versus Central Bank of India. This is also same view has been held by the Honorable Supreme Court. Detailed judgment, I need not trouble your lordship. Certainly your lordship will go through the judgment I have mentioned. So while writing judgment, certainly your lordship will consider this. Consistently, Supreme Court hold that pension has to be released. And for that reason, I have enclosed 3 Honorable High Court judgment, one of Delhi High Court, another of Calcutta High Court, which has been upheld by Division Bench of the Calcutta High Court, and another of the Madras High Court. These 2 judgments I can place before your lordship, because the Delhi High Court judgment is there, and this Madras High Court and Calcutta High Court judgment I am placed.
So other matters will have to, you take a date today, it will not be possible, other hearing cases. Because this will take some more time. You choose a date and.
Delhi High Court judgment, Commissioner Rao is there, and this is the 2 decisions of the Calcutta High Court as well as the Madras High Court, wherein the same view has been reiterated, quoting the Supreme Court decision. That one is regarding gratuity, that the special act will supersede the general act, and the Madras High Court specifically mentioned that gratuity should be payable and the pension should also be payable if there is no loss at all. And the pension is not dependent upon the bound. So that being the position, my lord, my submission is that both the pension and 50% of the gratuity should be released. And when this retired benefit has been released, terminal leave encashment 6 months. So there is no loss at all. So banks own surplus say if there is any loss, he is not entitled for any leave encashment. And if there is any loss, the same principle applies. If there is any loss, he is not entitled for the leave encashment. because since being there is no law, he should not be deprived of his leave encashment of 180 days privilege. That is also the decision of the Honorable Justice, Delhi High Court, in the Commissioner office. So these are my limited submission. As your lordship said, that I shall try to be as brief as possible. So with this, I rest my argument here. So on this basis, bank's own pension regulation, to reiterate, gratuity, your own circular instruction, gratuity and pension rules and regulations, particularly pensions have been denied illegally. Competent authority has not taken any decision. And as my learned friend very relevantly point out, that Honorable Reed Court has not gone into the question of release of the terminal benefit, although I have mentioned in the writ petition, it has been specifically mentioned the terminal benefit should be released. But that has not been gone into. Only question is that disciplinary proceeding, bank will not, Honorable Reed Court will not interfere because there is no violation of the natural justice, sufficient opportunity has been given and technical lapses are there. Anyway, that is a closed chapter, my lord. So now this writ petition has come up on the basis of the appellate court's order, one presided over by Honorable Justice, Chief Justice Ajit Lamba and another by Honorable Chief Justice Sudhanshu Bhushan Dhulia. Possibly Honorable Justice Sudhanshu Bhushan Dhulia is now doing Supreme Court. That's why possibly that comes to your lordship mind that whether I have gone to Supreme Court. No, before he became elevated to the Supreme Court, he was the Chief Justice here, as your lordship knows very well.
The issue is with pension, gratuity and leave encashment. As far as gratuity is concerned, 50% was given to him. That was not challenged by the bank till date. And as far as gratuity is concerned, the established position is that if there is a special act and a general act, the special act will prevail. That may be, but still I would like to just place out the bank's position. Lordships may record it.
Special act means the bank's.
The Gratuity Act. The Gratuity Act has been held to be a special act. There are a number of judgments, YK Singla, etc., etc. I did not burden your lordship.
See, gratuity 50% the court has directed.
Yes.
You have paid it.
We have paid it.
There is no challenge to that.
No challenge to that.
Therefore, why should we go into whether he is entitled to or not? Because there is no order, forfeiture of gratuity is not there.
No, that is admitted position.
Second is pension.
Lordship.
Pension is what an employee earns due to the years of service he spends.
Lordship.
Correct. So if you want to deny him of pension,
Lordship.
there has to be an order passed to that effect by the competent authority. Here also there is no order. By the competent authority.
The stand of the bank is that there is a regulation. My learned senior friend has read out a number of regulations. The most important regulation is in respect of the forfeiture of pension. Is regulation 22. I will read out the regulation 22. It covers the position. Most of the judgments, that compilation that has been handed over to your lordships by the other side.
What is regulation 22?
The pension regulations, lordship will come to regulation 22 of that regulations of 1995, the bank's regulations. For feature of service.
Regulation 22.
Yes.
22.
22.
Again, since there is no precision, it's getting difficult to.
Lordship may perhaps take my. I have. If I may just borrow.
Section 22.
22, regulation 22. Lordships have it.
Just 1 second.
I have flagged.
This is a part of Punjab National Bank Employees Pension Regulation.
Yes, the same pension regulations which was being referred by the Land Council.
22 forfeiture of service.
Resignation or dismissal or removal or termination of an employee from the service of the bank shall entail for forfeiture of his entire past service and consequently shall not qualify for pensionary benefits.
Yeah, this has been qualified by regulation 42 to 48 and the Honorable Supreme Court judgment, Honorable Mr. Justice B.K. Sharma's judgment, all Honorable Supreme Court judgments specifically mention that this type of section 22 should be dead letter. In the judgment, Supreme Court judgment has been
If I may
mentioned.
just clarify.
Because of the fact that regulation 42 to 48.
Not regulation 42
42
to 48.
to 48. Why this? It is a general clause, section 22. But as your lordship knows that Supreme Court decision is almost like a law. So
But,
they did not agree for
but
40.
This clause 42 is not under challenge, 22 is not under challenge.
No, never has been.
Now, on the basis, yes, in the Supreme Court judgment, in the Rajasthan Saha, it has been challenged, they have been whole that this regulation has been dead
No,
letter.
Mr. Adhikar.
Yes,
Supreme Court has different powers. You
My-
know, under
my-
41. What Supreme Court does is another thing. But this is obviously not the Supreme Court. We will have to go by our powers under Article 226. correct?
right, my lord.
Now, he has pointed out clause 22,
Right, my lord.
which says in case of removal from service,
Right.
which is the case here,
Yes, my lord, yes.
pensionary benefits will stand forfeited. There is no order required. If this clause is not under challenge, then will the court not have to go by this clause?
But my lord, this clause has been diluted by clause 42 to 48. And in that respect, I have provided a circular of the IBA also, that is in the there. IBA has provided that amend the bank's pension regulation and pay the pension because of the section 22. And that IBA circular is there and Punjab National Bank has amended it. Rajasthan Sharma's case judgment, it has been specifically mentioned that rules has been amended. IBA circular is there, my lord. I have included.
I have the circular 2020. I have not placed it on record because my lord, it would unnecessarily burden your lordships. Regulation 22 remains very much a part of the record. My lords. Regulation 22 is not affected by 42, 43 to 48. My lords. And 42 to 48 are in a different context, while 22, my lords, has not been set aside or diluted by any court whatsoever. The question of gratuity is a separate question, my lord. Gratuity has not been diluted. It has not been. It comes under the Payment of Gratuity Act. Justice Sharma's order as well as Justice Ujjal Bhuiya's order, they follow various earlier orders of the Supreme Court, including in Y.K. Singla's case, where it was specifically held that the provisions of the Gratuity Act would override the bank the regulations, specifically Regulation 46, which my senior friend has read out. So gratuity and pension are not to be confused, as one and the same. Gratuity would be treated separately, 50% he has got, and I must concede, without your lordship recording so, that 50% he will get. But as far as pension and leave encashment is concerned, this is a case where he was terminated. Termination itself is no longer under challenge. That the division benches said so. Now, whether Regulation 22 read with 42 to 48 would bar him or not, that is the question. Because if we dilute 22, then 22 would end up being a dead letter. And nowhere in no judgment has it been termed to be a dead letter. Because a bank, let us forget a bank, any employer for that matter, would necessarily have to have the right to withhold that part of the pension or benefits if he terminates. Because here is a case of termination, where there was an admitted case of misconduct. Well, now we are no longer on the merits of the termination. The termination is there. It has been upheld by the division bench. Lordships are not going to the question of termination. Lordships are going into what follows consequent to the termination. Now, if Regulation 22 is given its full play, as it must, because it has to be strictly construed. The removal has been by way of a termination without disqualification for future employment. At the end of the day, it is a termination on the ground of a misconduct. There was a departmental proceeding. He admitted to certain acts of misconduct, omission, and commission, and thereafter he was terminated. Now, the stand of the bank remains that Regulation 22 operates automatically. Yes, my lord, in the case of gratuity, there would have to be a speaking order passed. Probably he would have to be given a personal hearing also. But in this case, my lord, regulation 22 operates automatically. The moment is terminated, my lord, the pensionary benefits are gone. So pension and leave encashment, my lord, there is no question of his entitlement. Gratuity, my lord, yes. Prime officer, my lord, he is entitled to that. And as far as the judgments, my lord, that they are being relied upon, Bank of India versus SK Cool and other judgments, every judgment is in the case of the employees who are workmen, my lords, who are covered by the protection of bipartite settlement. Bipartite settlement, that is why I filed an affidavit, it must be in the record of the writ appeal, my lords. The bipartite settlement covers the case of the workmen, because as it is, my lordship knows that the workmen get a very paltry pension and their service conditions are not on par with the managerial cadre or the officer cadre. But the officer cadre doesn't have that protection. It is the bipartite settlement covers only the workmen. Bank of India, SK Cool, he was a clerk. The Shashikala Devi's case relied upon by the petitioner, also a clerk. There is no case, my lord, in which the pension has been given to a person who has been terminated, my lord. Because he has been terminated. That is the admitted position. So, my lord, regulation 22 has to be given its full play, my lords. It cannot be termed to be a dead letter because it has not been held to be so by any court. And the question of gratuity need not be confused, my lord, with the question of the pension.
My lord, honorable.
I'll just, sorry.
Yeah, sorry.
But if I may just clarify the position by way of a judgment of the Madras High Court. But this is 2015 labor and industrial cases 1549. But in this case, my lord, a similar type of situation had arisen. If your lordship will kindly turn to the second page, para 4. Your lordship said it. The contention, if I may read, the contention of the learned counsel for the appellant before this court is that once the punishment of termination has been converted to one of compulsory retirement, the appellant is entitled to encashment of privileged leave under provisions of regulation so and so of the Bank of Baroda Officers Service Regulations 1979 for short so and so. In support of this contention, the learned counsel relies on the decision of the Supreme Court in Bank of Baroda versus SK Cool through LRs. The other contention of the learned counsel for the appellant is that in the absence of any express prohibition in the service regulations, qua grant of privileged leave in respect of a compulsorily retired person, the Bank of Baroda Officer Employees Regulation cannot override the service regulations, and as such, the appellant is entitled to encashment of privileged leave. Is yet another argument is that when the appellant is entitled to retirement benefits and other terminal benefits such as gratuity, PF, and pension as a natural corollary, he is entitled to encashment of privileged leave as well. The appellant further claimed leave encashment and also treatment of suspension period as duty period. Per contra, the learned counsel for the respondent bank would submit that the appellant was not fully exonerated and that the punishment of dismissal from service was converted to one of compulsory retirement only for the purpose that he and his family could lead some respectable life in the society without a taint of dismissal. Further contended that the under the provisions of the service regulations 1979, encashment of leave is permitted only when an employee earns leave during his service. Further, according to the learned counsel, so far as treating the suspension period as duty period, we are not concerned with this part. Your lordship will come to the last page, my lords, para 14. In Bank of Baroda, lordship said, in Bank of Baroda Supra, the Supreme Court was considering the case of a clerk who was held as a workman. The Supreme Court found that the workman was entitled to the benefit of bipartite settlement signed by the Indian Banks Association and the Bank's Worksmen's Union with regard to the disciplinary action procedure. In that context, the following observation was made: the bipartite settlement tends to provide a punishment which gives superannuation benefits otherwise due. The construction canvassed by the employer shall give nothing to the employees in any event. Will it not be a fraud bipartite settlement? Obviously, it would be. From the conspectus of what we have observed, we have no doubt that such of the employees who are otherwise eligible for superannuation benefit are removed from service in terms of clause 6B of the bipartite settlement shall be entitled to superannuation benefit. This is the only construction which would harmonize the two provisions. It is a well-settled rule of construction that in case of apparent conflict between the two provisions, they should be so interpreted that the effect is given to both. Hence, we are of the opinion that such of the employees who are otherwise entitled to superannuation benefits under the regulations, if visited with the penalty of removal from service with superannuation benefits, shall be entitled for those benefits, and such of the employees, though visited with the same penalty but are not eligible for superannuation benefits under the regulations, shall not be entitled to that. In the case on hand, Considerably, the applicant was a senior manager and his service condition was not governed by under any bipartite agreement, which was the subject matter in Bank of Baroda, and thus the said decision is of no
Acha,
assistance.
Mr. Adhikari,
Yes.
will it be possible for you to make another trip to Guwahati in connection with this case? I would like to go a little deep into the matter.
Yes. As your lordship direct, I have to, because if it is possible, this month or after vacation.
After vacation.
That will be better, my lord. But it should be in such a fashion that at least I can go back on the same day. That is today, as your lordship has given me the
Yes,
accommodation.
we'll keep it as fixed parted matter.
Right, my lord, it requires detail. And regarding the cool judgment, my lord, I have mentioned, it has been specifically mentioned, section
just a minute,
22 is a dead letter.
Just a minute.
Yes.
I would like to go through the
Yes,
judgments
my
from
lord.
your
Great.
perspective.
Yes,
Right.
I will make it.
Today, the time.
The time is not there. So if your lordship after vacation fix a date, and if it is in the early morning, that will be when before this age, that will help me. I can go back on the same day.
So we have it on 10th of August as the fixed parted matter.
Yes, yes,
Then
my
it
lord.
will be
Grateful.
Top of the list.
Yes, top of the list. Grateful, extremely grateful, my lord. Because it requires, my lord.
You take your book back next day. Let him make the pagination.
Pagination, I will give.
We will go through the judgments.
Right.
Because this area needs to be threshed out.
Right.
As far as the gratuity is concerned, what
He has
says is-
conceded. But so far pension, he is relying on section 22, but cool judgment say that it is a dead letter, as your lordship find out. So other thing.
So 5 lakhs is in the pocket of your client.
Yes, ma'am.
That is there.
Yeah, ma'am.
Now, how much you can improve it for that?
Right, grateful, ma'am.
So part of the job is done today.
Yes.
Balance part, we'll have it on 10th of
August. Because particularly 1971 judgment, 4-bench judgment, constitutional judgment, that specifically say that pension has to be given, come what may. So my junior will make the page mark and submit it to the court master. This so that it will be help your lordship to go through the judgment.
Yes.
Yes. I will take it and we will make the page mark. He will submit before 10th of August.
You want to take this back? This is your written argument, is it?
No,
No,
this is my,
Not mine.
both are my written.
I dare not make such a huge.
He has borrowed it from me and given it. So you can give.
I mark the regulations for your lordship's convenience.
I will see to it in just now.
You give it on your next trip. That is when we'll close the matter. We'll go through the
By making the page mark.
page mark.
Okay.
And then we'll take it. Because I'll
Grateful,
try to dictate the judgment in the court itself.
Okay, grateful.
Have you called someone?
10th of August.
10th.
कोई बोलते मोटा बोल दो
ওটা বলে
You take down. Heard Mr. M.R. Sharma Adhikari.
M.R. Sarvadhikari. M.R. Sarvadhikari.
M.R. Sharba.
Sarvadhikari.
Sarvadhikari. Learned counsel assisted by Mr.
S.A. Borbuya.
S.A. Borbuya, learned counsel for the writ petitioner. I have also heard Mr. A.K. Ganguly.
no K.
A. Ganguly, learned counsel appearing for the respondents. Full stop. After the writ petition was dismissed by the learned single judge in respect of the challenge made to the order of penalty, and the matter having been remanded back to this court by the order dated 21/4/2021, passed by the division bench in retaping number 313/2019. Mr. Sarvadhikari submits that the only live issues arising for consideration in this writ petition at this stage is pertaining to the claim of the writ petitioner for payment of gratuity, pension and leave encashment.
My lord.
Full stop. In support of the above stand, the learned counsel for the writ petitioner has addressed elaborate arguments so as to convince the court that a writ of mandamus would lie in this matter. Full stop. Mr. Ganguly, on the other hand, has fairly submitted that insofar as the claim for payment of gratuity is concerned, since 50% of gratuity has already been paid to the petitioner under the order dated 8/9/2014, passed by the learned single judge in WPC number 4500/2014, and the said order has not been assailed in any proceeding, the petitioner would be entitled to receive the balance portion of the gratuity. However, insofar as the claim for payment of pension and leave encashment is concerned, the respondents' counsel has registered such a prayer by referring to the provisions of the what is this rule?
Section
called?
22.
Regulation 20.
Regulation 20.
Regulation 22
Referring to the provisions of regulation 22 of the
PNB Officer Service Regulations.
Pension
regulation.
PNB pension regulations
pension regulations
of 1979.
of 1979.
No, pension regulation came in
1995.
1995.
95.
93, amended in 1995. Make it 1995, my lord.
1995 as amended. Full stop. The hearing remained inconclusive today. As such, on the request of learned counsel for both the sides, this matter is directed to be listed again on 10th of August 2023 as a fixed part-heard matter at the top of the list.
Grateful, my lord.
That's all.
Grateful. Well, said.
At the top of the list.